Good morning, everyone. We'll now call the committee to order. Representative Marston, you're recognized to lead us in the Pledge of Allegiance. To the flag of the United States of America, and to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
The committee now calls.
We have to open the hearing.
He's running on.
At this time, we'll now open the public hearing on Senate Bill 306 relative to the penalties for various motor vehicle violations.
The committee now calls Senator Reagan.
Good morning, Criminal Justice and Public Safety. I'm Senator John Reagan from Senate District 17, and I bring to you today Senate Bill 306, which is a bill that passed in a previous session of the Senate and then got lost in the disaster that was COVID. So here's your chance against the penalties for distracted drivers who are violating the no electronics. And today is a victim of a distracted driver who it's looking like decades of pain and suffering because of a distracted driver. So I will let Lisa Bodwin explain the tragedy that struck her life from the distracted driver and was the driving force to our creating this legislation.
Representative Burt.
Thank you, Mr. Chairman. How do we, I guess, how do we enforce this when the police aren't enforcing it? You know, because, you know, I see them texting all the time. You know, I don't know if that's what this is about, but, you know, I'm sitting at the red light and there they are texting away just like the other cars in front of them and everywhere else. So how do we enforce this if they're not enforcing it and they're doing it themselves?
I think the greatest impetus to this is the penalty that happens if you're charged. And apparently the current penalty is not enough to make people stop doing that. So that's the hope with the enhanced penalty.
All right, thank you.
Representative Bourdonnais.
Thank you, Mr. Chairman. Thank you for taking my question. It says on sentence C, offense would constitute a Class A misdemeanor would be charged to a Class B felony. Can you give me examples of violations that would make a Class A misdemeanor?
I'm not an attorney and not a law enforcement officer, so I can't help you with that.
Thank you very much.
Representative Mangiapudi.
Thank you, Mr. Chair. Thank you, Senator, for taking my question. Wasn't this bill, not last term, but 2 terms ago, that was passed? And didn't we have a lot of data in terms of the crash and fatal crashes in state that had texting just before the car crashed? And if I recall, I was on this committee at that time, and many teenagers, including my daughter, came up and said, this is wonderful to have so that it can save a lot of lives. Wasn't this the same bill that was?
Yes.
Thank
Yes.
you.
Representative Harry Gathright.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. It's kind of on the line of what the representative from Nashua stated. Was there data on this, how often this is happening and what have you? I don't recall it from.
There was at the time.
previous.
I'm not sure if anyone has that. Yes, we have that for you today.
Okay, thank you.
Seeing no hands raised, I want to thank the senator for his testimony.
The committee now calls Lisa Bowden.
Good morning. Chairman Abbas and honorable members of this committee. My name is Lisa Bodwin. Thank you for the opportunity to share my story supporting SB 306. It is critically important to me that some greater public policy good comes out of the challenges I and my family experienced due to a law-breaking, distracted driver. I am a devoted, hardworking executive director of a small nonprofit and the proud mom of 2 young men, Forrest, who lives here in Concord, and my younger son, Rowan, who is a senior at Wesleyan University. On December 19th, 2018, I was driving home from a meeting on Route 101 in Amherst when a driver took his eyes from the road, distracted by his phone, and cleared 2.5 lanes of traffic to crash head-on into my Toyota Prius and nearly killed me. The captain of the Amherst Police Department told me he thought the coroner's truck had already left when he arrived. That's how bad the scene was. In August 2019, while delivering an in-person thank you to the Amherst first responders who saved my life and share with them a happy ending, I learned that a veteran of 31 years in first response literally saved my life by sticking his 2 fingers into my left femoral bleed while the jaws of life freed me so that I could then be med-flighted to UMass Memorial Medical Center in Worcester. My sons and extended family sat terrorized for 2 days wondering if I would live or die. Neither doctors nor medication could control the excruciating pain I was feeling for 3 full days. Over the course of the first 8 days, I underwent 5 surgeries to repair multiple fractures across my body. I had 3 broken limbs, broken femurs in both of my legs. 1 femur was blown into 20 pieces. The other was a compound fracture which broke clear through my leg. Both knees were broken ribs, clavicle, scapula, and a broken left ulna. And these are among the many injuries that I am still recovering from. At one time, 5 metal plates, a titanium rod, and dozens of pins and screws held my body together. A device called an external fixator, which is pictured here, had 4 pins drilled through the outside of my skin and through my leg bones, which then immobilized my leg for 4 months. Those 5-inch pins were unscrewed while I sat awake in my surgeon's office. The pain was reminiscent of a medieval torture scene. For 6 months, I completed 2 to 3 hours of physical therapy a day. Over 3 years later, I'm down to 1 hour a day. Because of my injuries at the time, for 4 months, I needed round-the-clock care for bathing, dressing, eating, drinking, and the removal of excrement from a bedside commode. I am very lucky that my family, friends, and neighbors pulled together to help me, or I'd have been stuck in a rehab facility, extending to my significant recovery costs. To let my surgically fused bones set, both legs were non-weight bearing until the end of March. It wasn't until June when I was cleared to begin to relearn to walk on both legs. Needless to say, I am lucky to be alive after the reckless and careless conduct and decisions of a distracted driver who hit me. To date, I have had 10 surgeries and have had to relearn to walk 3 times. During most of 2019, my surgeon directed me to not engage in essentially all of the activities I enjoy: gardening, running, hiking, or any significant physical activities that would jeopardize the lengthy healing process required for me to be put back together. The driver's reckless conduct for basic standards of public safety also directly impacted my responsibility as guardian to my now 26-year-old son, Forrest. Due to my original injuries, for 9 straight months, I was unable to support my son at all. A young man who needs just a little bit of an extra helping hand to make his way in our beautiful Granite State. Due to ongoing surgeries 7, 8, 9, and 10 over the last 2.5 years, my ability to support him has been intermittent at best. My most recent surgery was on December 30th, just a few months ago in 2021. As executive director of a small nonprofit, my ability to perform my job effectively has no doubt been significantly impacted. And I love my job. I love what I do. Not only my job, but the future of the organization were put in jeopardy due to that moment of distraction of that careless driver. Again, for the better part of a year, I was not able to perform the basic tasks that we take for granted every day. I didn't shower. I didn't go to the second floor of my house. I couldn't cook a meal. I couldn't use a bathroom toilet. I didn't sleep in my own bed, and I couldn't even wear pants. My children wept through Christmas. I was unable to ride as a passenger in a car because of the external fixator for 4 months. My life now still includes physical therapy. And there will be 3 more surgeries in my future. The total costs now exceed $1 million. Every single moment is still rigorously demanding. Relearning to walk is excruciatingly hard, and this latest round since December has been particularly rugged. Snowy sidewalks are now scary, stairs are mountains, and I'll tell you, all night long, my right knee and my left hip take turns telling me exactly how they feel. I have a fierce and effervescent love for this fabulous gift called life, yet mine is forever changed. I was personally and professionally isolated in my home or in the hospital from December 2018 until September of 2019. I was at risk for losing my job, and those who depended on me were without my help. I wonder about people of low socioeconomic status who end up in situations like this. The nonprofit I worked for gave me 2 months of paid leave and allowed me to work from home. How does a waitress or an employee of Walmart or a mechanic in a car shop or any minimum wage or low wage worker not go broke or avoid homelessness if they are put into a recovery process like mine? Distracted drivers inflict harsh financial impacts beyond the physical costs of the injuries, costs of the physical injuries. I'd also like to let you know that first responders who train for hours to save strangers, people they don't know or love, are harmed by distracted drivers. They go into extremely stressful scenes like mine, scenes they can never unsee, to serve our communities, to provide physical and emotional support to traumatized survivors. They are true superheroes living in our midst. The chief in Amherst said to me, "Car crashes like yours are what make or break new recruits." People leave public service as first responders when they see accidents like mine. The driver who hit me served 60 days in jail. because current statute does not provide prosecutors the discretion they need to file for a Class B felony in those cases where serious bodily injury or death occurs. We must work together to put really sharp teeth into the penalties for causing serious bodily injury and sharpen the public's awareness of how serious distracted driving has become. I hope this committee finds SB 306 ought to pass, so those who are prone to distracted driving are deterred from making a reckless and senseless choice that would force another family to endure what mine has. Thank you.
Thank you for your testimony.
The committee now calls Lieutenant Brian Strong, New Hampshire State Police.
I'm confused. Wallace. Who did I say was in for Schultz? Didn't I say somebody?
Good morning, Mr. Chairman and members. Good morning. My name is Brian Strong. I am a lieutenant with the New Hampshire Department of Safety Division of State Police. I'm currently assigned as our commander of our Special Investigations Unit. And within the Special Investigations Unit is where our Collision Analysis and Reconstruction Unit is located. They are responsible for investigating serious bodily injury crashes and fatalities throughout the state of New Hampshire. Early on in my career, I was part of this reconstruction unit for 12 years, where I investigated hundreds of crashes to include serious bodily injury and fatalities throughout the state of New Hampshire. I am here today on behalf of the Division of State Police to support SB 306. New Hampshire as a state has come a long way with handling distracted drivers. Distracted drivers is one of the top 3 causes of serious bodily injury and fatality crashes in New Hampshire and pretty much throughout the country. I believe our hands-free law went into effect back in 2015 in an attempt to help reduce distractions and crashes. Now, this law hasn't stopped everyone from using their handheld devices while driving, but has definitely reduced that type of behavior. I believe by adding the proposed language that's outlined in RSA 650, or excuse me, by adding the proposed language to RSA 651:2 to those offenses that are listed in the proposed 265, 265A, and 630:3, which are based on facts and prohibited use of mobile electronic devices while driving a motor vehicle, would be subject to enhanced offenses outlined in this bill. I believe this is another way that we can help curb this type of behavior by increasing the penalties for certain violations, and also letting people know that should you decide to use an electronic mobile device while driving and are involved in a crash, you would be subject to face more severe penalties. Now, by no means, by adding this language is going to stop this from happening around the state. We hope to curb it and reduce the numbers, and I think this is one step further that we can take as a state. Thank you.
Representative Mangiapudi.
Thank you, Mr. Chair. Thank you, Lieutenant, for taking my question. Back in 2015, when hands-free restriction or distracted driving bill was passed, what kind of penalty did that have? Wasn't it just a ticket in that time? Also, we had the data from
Yeah.
the police. Do you
Yes.
still have that?
Thank you for the question. Back in 2015, and I think it's even current today, that should you be charged with using a mobile device, it's just a violation. It's a fine. There is a second or subsequent offense and a third offense. It just elevates the dollar amount. Should you be charged?
Follow up, Mr. Chair?
You're so recognized.
Thank you. Would you still have the data that, it was presented? I was on this committee at that time. Number of crashes, number of data based on crashes and who was using texting minutes before the crash, that kind of data. Do you still have that available?
So thank you for the question. I currently do not have that with me currently, but I believe within Department of Safety that that data should be available. Yes.
Thank you.
Representative Bourdonnais?
Thank you, Mr. Chairman. Thank you for taking my question. I'm really not familiar with a lot of the transportation laws. So can you tell me what constitutes a Class A misdemeanor in this bill?
So if you look in, and I don't have the my RSA book in front of me, but I think if you look under the negligent homicide, the 630:3, it's going to outline probably what classifies a misdemeanor or a B felony. The other violations on the 265, 265A, which are outlined in this, those I believe the primarily are violations. The DWI statute, I think, is under that. That would there's potential to elevate that. And I don't have my book in front of me, so there might be another one. I'm sorry that I don't have that in front of me.
All right. So basically, it is a bodily injury type of accident that someone is involved in and they caused it. Is that what I hear?
For the elevated
No,
charges?
just for Class A misdemeanor without the elevation.
As far as I'm reading this statute here in front of me, and let me just get to it. It looks like it's adding all these RSAs, the 265, the 265A.
Right.
The 265 is rules of the road, I believe, and that would be majority of them, I think, are violations. Like for speeding, I think that falls under that statute for rules of the road. Some of the ones that are elevated would be like your DWIs, and I believe they have enhancements for serious bodily injury and fatalities. Your negligent homicide, there is enhanced penalties for that also. And I'm sorry, I don't have my book in front of me to clarify further.
Representative Bourdonnais?
Thank you. I guess I'm a little concerned where we're moving from a penalty of a Class A misdemeanor to a felony. I would like to really know what we're talking about.
Mm-hmm. Again, I don't have the actual books in front of me for the statutes, but I think if you look under 630:3 for the negligent homicide, there's a certain statute and it'll say what the penalty is. We are looking to see if if the mobile device is involved in the causation of the crash, that it goes up one step from where it currently is.
Thank you very much.
Representative Newman?
Thank you, Mr. Chair, and thank you for taking my question. When one of these violations appear to have been broken, if there is a crash or an accident or whatever it is, and the police arrive on the scene, and they arrest or detain somebody, when is the person charged? So, because it says when they are charged that these enhancements may be made. When does a person that has been involved in an accident like that charged? Could you just kind of explain that process to me so that I know when this would actually take effect, because it probably would.
Sure.
When they're charged.
Absolutely. So from my experience, and I was many years on our accident reconstruction unit. When we go out, it's for the most severe and heinous crashes in the state. Primarily, those take lengthy investigations, and obviously to actually make a determination if somebody is on a cell phone at the time of the crash would not probably be made at the time of the crash. You would have to look for further investigation into that. So there would be an investigation before probably likely a charge would come out of it. I can't speak for every case because every case would have certain or different circumstances. Some would be quicker, probably to come to a resolution, and some may be a little longer. Does that answer?
Just follow up.
You recognize for a follow-up.
In instances where there may not be any injury, is it likely that the person would be not be charged that day and would be released? What's the likelihood when there is no injury of being charged?
Again, I can't speak for everybody in every police department out there as whether they'll charge somebody right on scene or if they're going to charge them with a certain violation. I think the moral of this bill here is to try to curb people from actually using devices. And I think if they're aware of that, of the enhanced penalties, that may help curb the use of it. It's not going to completely stop it. I'll be frank, it's not complete. But if it curbs, a handful, a certain percentage, I think that's a win.
Thank you.
Representative Marston?
Thank you, Mr. Chairman. Thank you for taking our questions. I'm interested in finding out how we're going to enforce this law for a starter. How do we enforce it?
As far as the hands-free law, or as far as enforcing increased penalties?
Any part of this bill. How are we going to enforce it?
So I believe the first step within enforcing it is actually to get it on the books. So then there is a way to enforce it. And then when we have serious bodily injury crashes, there is a lot of communications with either the county attorney or the attorney general's office, depending on the case at hand. And they make a lot of the determinations and factual decisions for certain charges.
Follow up, Mr. Chairman?
You so recognized for a follow-up.
Thank you. What I don't understand in your answer has to do with the fact that when you're doing a reconstruction investigation, are we using every tool at your disposal, such as getting warrants for the person's phone, for just a simple example?
Absolutely.
Thank you.
Representative Mulhern?
Thank you, Mr. Chair. Thank you for taking my question. First question, I guess, would be is in 2015 when the law was passed for the mobile devices, there was a big push. There was a lot of advertisement.
Andrew, move that closer.
Can you hear me now? Okay, sorry about that. Back in 2015, there was a big push. There was a lot of advertisement to push for the to write tickets, to make people aware. I guess the question I have is, since then, is the enforcement of writing tickets still there statistically, or has it dropped off?
I don't have complete statistics going back as 2015, and just briefly before I tried to gather some statistics coming in here in case I was asked. In 2020, it looks like there was 4,673 tickets or citations issued for hands-free violations. In 2021, so a year earlier, or actually a year
Later.
yeah, 2021, so a year later, I'm sorry, is 3989. So we've it has been reduced. Like I said, there's going to be people that are going to continue to do it, just like the speed limits are certain. People are going to push the limits. So
Representative Mulhern?
So I guess my question is the same thing going to happen from 2015? We're going to have a big push, and then all of a sudden it's just going to drop off, and the enforcement is not going to be there?
I can't speak on the enforcement. I can tell you that for the state police, I've been here 22 years. We take enforcement serious, and we do pushes out there. And I know we have certain, patrols that we go to, I say target, but look for people that are using mobile devices.
Representative Mangiapudi?
Thank you, Mr. Chair. A follow-up to Representative O'Haron. You said in 2021, number dropped, but it was also in the middle of pandemic when a lot of people were working from home. So the data from 20 to 21, would that have affected?
Thank you for your question. I guess that's possible. I don't have the previous years to go back. I'm sure the data is available. I'm sure we could easily get the data if you needed to look at it. I just don't have it with me.
Representative Burt?
Thank you, Mr. Chairman. Why wouldn't this bill enhance all distracted driving and not just the hands-free part? Because I've seen people, eating food, putting on makeup, reading newspapers up through the tolls. That was a funny one. There's a lot of distracted that could cause accidents. And do you know the separation of how many accidents are caused in distracted driving laws? How many are the the cell phones, and how many are eating a banana, reading newspapers? Is there a separation there? Do you keep track of that?
Thank you for your question. I don't have that data with me. I believe that is tracked. However, I don't know definitively because I am not a person responsible for tracking the data. I am aware of, your examples of other people putting on makeup, eating, reading. Yeah, that happens. There are a lot of distractions that drivers put themselves in. There's probably more that the state can do to make the rules of the road safer. This is one of them, because a mobile phone, wherever you go, is attached and glued to just about everybody. And some people live on their phone, to include when they're driving. And I think if we can curb that, that will help. Is it going to curb everything? No. There's probably more that we can do, but it's a start.
All right, thank you.
Representative Conley?
Thank you, Mr. Chairman. Thank you for taking the question. We've heard enforcement come up several times. Forgive me if you addressed this already. Can you explain how the department would even get to a place where they would want to subpoena phone records to even know whether a phone would be involved? How do you even get to that point?
So you have to have, sorry, thank you for your question. So first of all, you have to have some type of, articulable suspicion or reasonable grounds to believe that a phone was in use. So obviously, if there's a crash and there is no phone anywhere, you just can't jump to, we're gonna look for that. Most likely, there'll be a phone present. You talk to witnesses. There's a process to go around to get us to that point, and then you have to apply for certain legal process to get records, cell phones, data, etc., and all that. When we reach those thresholds, we follow up with those parameters to ensure we can look to see if somebody was on the phone at the time of the crash.
Representative Conley?
Thank you. And so, knowing that there is an established process for determining if a phone was involved, does that stand to reason that that same process would dictate how one would be charged with these enhanced penalties if this bill were to pass? So there's a process in place, and that process would continue if this passes. We're just talking about the punishment that would go to the offender. Is that correct?
Yes, thank you for your question. That is absolutely correct, because the process for investigating is not going to change. It's just going to be the penalty phase.
Thank you.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. So
there's a lot of, I think there's confusion regarding what constitutes unlawful use of a device. I think a lot of people are under the misconception that just because you put it in a holder and it's not in your hand anymore. Could you explain to us and the public at large what constitutes, what is legal and what is not legal with regard to using a phone or any electronic device in a car?
Sure. Thank you for the question. Basically, obviously anything handheld, because it's handheld mobile devices, anything that's actually going to be in your hand that you are using to text, phone call, communicate, read. Now, there are phones that are put into a holder that'll go through Bluetooth. That is eliminating the hands-free, manipulating the actual phone while you're driving. That's where you're going to have the issues. And when you got to actually manipulate the phone, you're going to look down for a brief second or longer to manipulate it. So it's the actual manipulation of actually the phone. To, you know, dialing to make phone calls, texting, reading the text messages, the actual course of physically using a handheld device.
Just a quick follow-up. So, for example, if I have my phone in the holder, it's one of those cup deals that it's pretty convenient. It's not in my hand, but if I look over and answer a text, is that still technically a violation of the law as it stands?
Thank you for your question. I would say, I believe, yes. I'd have to just re-clarify. Yes, but I do know some people use their phones. They put it up on the dash for GPS. So it's up there. It's navigating.
Okay, thank you.
Representative Conley?
Thank you. Just piggybacking on what my colleague just asked, many cars with the Bluetooth, you know, goes through the Bluetooth, it ends up on your screen, and there's some manipulation involved. Does that constitute, just would that trigger this law? You know, to dictate it, you sometimes press a bunch of buttons.
Thank you for your question. I would have to research that further. Off initial inclination, I would probably say probably not, because a lot of the cars have mobile screens now, and they're touching. You know, you are manipulating that as you're driving. You're turning the radio. You're checking for. You're moving through the screen. So, I would have to look for clarification on that.
Thank you.
Thank you. One more question, and this kind of brings me back to what Representative Burr asked. It seems like we're chasing technology here. Every time we pass a law, technology advances, and now we're back out of it again. Wouldn't it be better if we more generalized distracted driving, so that we didn't necessarily pin it to a specific set of circumstances? In other words, I can text from my screen that's built into the car now. There's so many things I can do. These cars have become, you know, it's like a spaceship. So you're still distracted, whether it's in your hand or it's there. What do you feel about making it more general instead of tying it just to a certain set of explicit circumstances?
Thank you for your question. Personally, I think that would be good. We have negligent driving. There's a statute for negligent driving, and that would or could encompass people that are driving and doing other things besides paying attention.
Mm-hmm.
The biggest thing is really the phones, and I think tackling that is a monster in and of itself. And you're right, technology is always going to be changing. The phones are changing. You'd be hard pressed to walk anywhere and see somebody not having a phone or on a phone. You can't even go to dinner now, and everybody look at a booth and they're not even talking across from the person they're sitting next to. They're down. Their life is their phone.
Mm-hmm.
I think that's one that should definitely be targeted. I hate to use the word targeted, but should be actually looked at.
Thank you. There being no further questions, thank you for your testimony.
Thank you.
The committee now calls Holly Haynes.
Thank you. My apologies. Thank you, Chairman Abbas and honorable members of this committee. My name is Holly Haynes. I'm a former president of the New Hampshire Association for Justice, and I'm an attorney in Manchester, New Hampshire, representing many victims of car crashes like Ms. Bowden, who have been injured catastrophically by distracted drivers. Before I begin my testimony, I've just distributed written testimony for all of you, and I believe that page 2 may answer some of the questions that Representative Mangaputi had, and I hope to be able to answer some other questions, but I want to make sure that we understand exactly what this bill does. We may have gone a little bit afield because it's not creating any new laws regarding mobile electronic devices. It's not creating any new crimes at all. All that it does is give prosecutors additional discretion when they are charging offenses after a crash has happened, after an offense has already happened, and it gives judges additional discretion at sentencing. For example, one of the questions were, what are examples of violations that would be elevated or Class A misdemeanors that might be elevated? RSA 26579 is reckless driving. RSA 26579B is negligent driving. Both of those right now are considered violations under New Hampshire law. Those would be elevated to Class B misdemeanors. RSA 26579A is vehicular assault, and that is currently a Class B misdemeanor that would be elevated to Class A. These types of violations, in Ms. Bowden's case, I believe that the driver was charged with reckless driving and vehicular assault. He received a minor fine and 60 days in jail. She, as you just heard, has been dealing with this for 3 years now, more than a dozen surgeries, and she's going to be dealing with it for the rest of her life. I have to say that justice was not served in her case in any way, shape, or form. The benefit of this, it's not changing crimes, it's not adding crimes, it's just reflective of the societal outrage now at distracted driving, the public safety issue that we have, similar to in the 1980s, the societal outrage we had against drunk and drugged driving. In response to that, we changed our criminal code. We added discretionary enhanced penalties for aggravated drunk driving, when a drunk driver caused an accident with serious bodily injury or death. The prosecutor has the discretion to charge it both as the regular drunk driving offense or aggravated or the vehicular assault offense. It just gives the prosecutor added discretion to enhance the charge, and it gives the judge added discretion to enhance the penalty at the end. It's not going to change anything with regard to the actual crash itself, the investigation by the police or the state police or the enforcement. As we saw after drunk driving and drug driving laws were enhanced, the incidences of drunk driving have decreased. It has made our roadways safer. That's exactly what we're asking to do with this bill with distracted driving. It will make our roadways safer if prosecutors have the discretion and drivers know that if this happens and they cause a crash that harms someone like Lisa Bowden or any other citizen of the state, they may be going to jail for it. They are going to have enhanced penalties, and they're going to have something they're going to recognize, truly be punished, and hopefully this will have a deterrent effect from them driving distracted. As you heard from Lisa, there are so many secondary harms that no one thinks about from distracted driving. We're just thinking about what is the mobile device, what are people doing, what are they texting. People are losing their lives, they're losing their limbs, they're losing their loved ones. Some families, Lisa incurred more than $1 million in medical bills. This driver was not insured, did not have enough insurance to compensate her. In a case like that, families can be put into financial ruin with medical debt. The driver spent 60 days in jail, and now he's back to his day job, working every day, not thinking twice about what happened to Lisa. Lisa and her family are going to live with this for the rest of their lives. If this was someone in a service industry, for example, a waitress, a car mechanic, someone who doesn't have an employer accommodating like Lisa's was, that was able to give her some flexibility with her job, they would not only go into financial ruin from medical debt, but they would from inability to have their own income, while the offender is going back to work right after. This is a critical bill that we need to deter distracted driving. It will have a benefit to public safety, and I think is something that everyone can get behind. It's not going to change the burdens of proof for prosecutors at all, other than they'll have to prove the prohibited use of an electronic device. It just gives them an added charging mechanism. Prosecutors often bring multiple variants of charges, lesser included offenses when they charge defendants, and that this is just going to give them a higher elevation of a charge of an offense to charge at the same time. And I just want to emphasize that it is just a discretionary option for prosecutors and for judges at sentencing. This isn't mandatory. It just gives prosecutors and judges more discretion to enforce the laws, enhance the deterrent effect of distracted driving, and increase public safety. Thank you for your time, and I'm happy to take questions.
A question from the chair. In Ms. Bedoin's case, did the perpetrator receive the maximum sentence available at the time?
He did not. And we actually, the police prosecutor from the Amherst Police Department was reticent because of the limits on the laws to ask the judge for additional penalties. I asked him to ask for restitution, to ask for the maximum jail time, to ask for the maximum fine, and he was reticent to do that. Ultimately, I asked the judge for that on Lisa's behalf, and the judge declined to order restitution because he found if someone was in jail, they wouldn't be able to work and they wouldn't be able to pay restitution. And this person did not have funds. You can't get blood from a stone, I believe would be the quote from the judge. And I don't think that reflects justice. If this was available and to the prosecutor, I believe that he would have asked for the additional charges and the additional sentences. It's because it wasn't available. He had never done it before, and he was concerned about what the judge would do, that he didn't ask for additional penalties.
And a quick follow-up. You mentioned he didn't have insurance. Was he required to, for any reason, have insurance but didn't have it, or was he just not opting and legally not obliged to have it?
So I want to correct one statement. He was underinsured. He had a minimal policy. I don't believe he was required to have insurance because he owned his truck. It was an older model truck and wasn't subject to financing, and he wasn't under an SR-22.
Thank you. Representative Burt.
Thank you, Mr. Chairman, and thank you for taking my question. I guess it's on the same level as, so you're telling me that there was more penalties they could have gone after, but the prosecutor elected not to. Is that correct?
Ultimately, the case resolved, I believe, in a plea bargain for the defendant, and that may have been one of the reasons. But the penalties weren't higher for incarceration. I believe 60 days may have been the maximum. I'm not sure about that. I'm not a criminal prosecutor, so I don't want to misspeak about that.
In a follow-up, Mr. Chairman? Thank you, Mr. Chairman. So with the current laws, what could he have gotten for jail time, the full, if they didn't take a plea deal?
So for reckless driving, it's a violation, and it is a fine of no more than $750 for a first offense and no less than $500 plus penalty assessment, and loss of license for 60 days. For the vehicular assault charge, it's a Class A misdemeanor, and actually it doesn't say, but I believe that that's a fine of up to $1,000, and I'm not sure of the time for the jail time. I think that there are criminal lawyers who may be able to speak to that are here today.
All right, thank you.
Representative Mangiapudi.
Thank you, Mr. Chair. Thank you for taking my question. I have two-part question. One is, back in 2015, when initially the distracted driving law was enforced or passed, was also considered for the vehicles, do they have the Bluetooth option or hands-free option? Because up until then, not all vehicles had that option. Has that changed No, I know personally I had to change my car because I didn't have the Bluetooth. So that one. And or do you want me to ask the second question after?
Thank you for that question. I don't know the answer to your first question, so if you'd like to ask
Okay.
your second question.
Second question is about at that time, distracted driving included a generic overarching, but the data at that time that we got on this committee was predominantly the deaths due to crash, and few seconds before the crash happened, they had the data on texting, use of mobile phone at that time. So that was the predominant cause for the fatal crash. Do you have any of those data?
So what I did present in my testimony on page 2 is the information from the National Highway Traffic and Safety Institute. They do keep data on distracted driving and crashes, not just involving injury. The average since 2017, there are almost 1 million crashes every year caused by distracted driving or use of mobile electronic devices. Of those crashes, more than 400,000 involve injuries and 3,000 involve deaths. In New Hampshire alone, the data I have is from 2017. I suspect it's probably similar. It may have gone down in 2020 or 2021 because of less people on the roadway. But there were 9,000 crashes a year as of 2017 and 2018 that were involving the use of mobile electronic devices and distracted driving.
One last follow-up, Mr. Chair.
Last one.
Thank you. How many other states have instituted this?
I do not know the answer to that question, Representative. I'm sorry.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. I'll just not see you, but that'll be okay. You described in your written testimony and in the testimony you gave here about the way this person was charged, and could you just elaborate on that a little bit? That the judge is the one that made a charge, and you mentioned something about the Amherst Police Department
No.
in a discussion. Could you just kind of clear that up for me?
Yes, thank you very much, Representative. After a crash, the Amherst Police Department investigated the crash, and it ultimately, Amherst does not have a legal prosecutor. They have a police prosecutor who's a captain in the Amherst Police Department. He is who makes the charging decisions based upon the information that was gathered at the crash. And ultimately, he brings the charges against the defendant, and he and the defense attorney reached a plea agreement on the charges, and then it's brought to the judge for sentencing, and the judge can either accept or reject the plea agreement.
Thank you.
There being no further questions, thank you for your testimony.
Thank you so much. Thank you, members of the committee.
The committee now calls Bonnie Dunham.
Hi, my name is Bonnie Dunham, and I'm here in support of this bill. And Lisa's a friend of mine, and I've seen some of the horrendous impact of the crash that she was in. It wasn't an accident. Somebody on purpose decided that using a cell phone was more important than her life. And so I think that much of what I've written here has been already said, so I won't repeat it. But I think that it's unacceptable that somebody should be allowed to put their convenience before someone else's life, their livelihood, their family's well-being, and all of the contributions that that individual, somebody like Lisa, could make to society, and instead had to spend that time going through surgery after surgery, fighting for her life, physical therapy, and having pain as her constant companion. The impact on her family has been horrendous, and the impact on the community because of all the kinds of things that she does in her line of work and in her free time. The deterrent that this driver experienced was so low, I honestly can't think of how it would discourage him from doing it again. I don't know if he has, but I don't see that being a deterrent to him, and certainly not to others who, I think this is an opportunity to send a message to people that if you do this, if you put yourself before the life of other people just because you choose to act irresponsibly, then you will face a serious penalty. And just have it be loud enough that other people will hear it and change their behavior. That's all. Thank you.
Thank you for your testimony. Is there anyone else here wishing to testify who's not testified on this bill? Come forward, sir. Thank you. Mom, could you fill out a pink card for him?
Hi, my name is Forrest Diver Friday. I am representing and delivering my brother's testimony. He is in college now. Dear Chairman Abbas and honorable members of the committee, I appreciate the opportunity to speak today. I'm asking you to support Senate Bill 306 on December 19th, 2018 at 11:41 p.m. I received a call saying my mom had been in a terrible car accident. She was alive, but it was bad. I felt completely lost, powerless to help, and desperate for answers that simply were not coming. My mother's life was forever changed in ways that I cannot begin to comprehend, and our family still grapples with new, difficult discoveries on a regular basis as a result of the crash. One person's decision to endanger the life of another by using a mobile device affects not only that person, but also the lives of all the people around them. I spent Christmas Eve after the crash lying awake in the dark at the hospital on a makeshift pull-out chair, wondering if my mom would live to see the new year. In an instant, a stranger's decision to use his phone had taken away my family's ability find any peace or happiness at Christmas. We didn't get to choose when to have sleepless nights waiting for mom to get out of surgery. Now every time I get a phone call at night, I'm afraid to pick it up. I imagine answering to news that my brother Forrest has been hit by a car. I don't get to choose when people call. When they do, I find myself ripped from a normal situation into moments of terror and insecurity. Over the past 3 years, my family's sentence of uncertainty and pain has been oppressively constant. Hours and doctor's appointments on the phone with healthcare providers emptying bedpans. She wasn't able to pursue her life as she wished. We have been at the mercy of the consequences of a distracted driver's selfish and irresponsible actions for over 1,100 days. In contrast, the distracted driver who caused the crash allowed to self-report in May 2019 to serve his 60-day sentence. A measly 60-day sentence for utterly and irrevocably altering the lives of countless other people. Why does he get to choose when we do that? When we do not? How can this committee possibly claim to see any justice in his sentence? The answer is, it cannot. For there is none to be seen. New Hampshire's current penalties for distracted driving are half-hearted imitations of justice that pale in credibility before the incomparably towering and far-reaching consequences of the crime. The legislation needs to change. As a son whose mother, who was on the receiving end of a vehicular assault, I implore you to support SB 306 in favor of stricter penalties for perpetrators of the heinous, irresponsible, and yet completely preventable decision to drive recklessly. Thank you, and I am looking forward to questions.
Representative Manzaputi.
Thank you, Mr. Chair. Thank you, Forrester, for taking my question. And you read your brother's testimony. Are your sentiments very similar to your own? If you could write a testimony, would it be same?
Well, my brother Noah just moved to college at Wesleyan University. Yeah, I am very similar to Rowan because I am just representing Rowan because he is in college now.
Can I rephrase my question, Chair? Okay. Let me ask you this way.
Sure.
Forrest. Sorry.
Okay, sure. What I felt is that this was in 2018, and my brother Rowan called me about my mom. I was in Peterborough for 5 years, and I heard about my mom's accident. It reflected on me. I knew that this would make me feel a little bit nervous to see about how my mom was in a car accident, because it made me feel like what you are seeing here in these pictures, because I just felt a little bit disappointed about how my mom felt when she got herself in a position to hurt herself.
Thank you very much for your testimony today. We appreciate it.
Mm-hmm.
Chair has a question of Attorney Haynes, is she still here? She didn't, okay, all right, thank you. There being no one else to testify, you want to testify?
Hello, and thank you. I'll be very brief. Thank
I'll
you.
need you to fill out a pink card when you're done, okay?
I will. My name is Tina Bodwin. I'm Lisa Bodwin's sister. I got the first call when she had been helicoptered in. I think I'm in full support of this bill. Not only was my sister hit, and it was been horrific surgeries, and the amount of pain, and it obviously the repercussions for the man who hit her are nowhere near justice. I don't know if all of you feel this way. I'm nervous when I drive. I constantly see distracted drivers. Constantly. I myself was hit by a car on August 29th, 8 months ago. I'm on a bicycle by a distracted driver. It's rampant. They barely got I think they got a moving violation. There was no consequences. Very low fines. But for all of us and our families, I think we have to do a bit better to safeguard our families and the entire community and making the consequences more severe when people are operating a vehicle and cause serious injuries. Thank you for everyone's time and consideration.
Thank you for your testimony. Is there anyone else wishing to testify who has not yet testified on this bill? There being none, I hereby close the public hearing. The committee be in recess for 10 minutes. At this time, I'm going to open the work session on SB 294. And I'm going to open the floor up. Does anyone have any discussion they'd like to have on this? Representative Newman.
Thank you, Mr. Chair. I've stated a lot of times my concerns about the may and shall. I've talked about rebuttable presumptions and all of those kind of things. And have not been very successful with that. So I'm now approaching it from what the best bill would be to what kind of changes might make it more palatable to more people so that the bill comes out of committee with a recommendation. So in the past, I've also discussed there are a lot of folks that are concerned that when you have a list of crimes like we currently do, there are some of those crimes like domestic violence, and I can't list all of the other ones from the top of my head, where under the title of the law that we're talking about, there are a bunch of lesser crimes with lesser penalties that are included in that. So I thought that probably I could support something with this list of laws that somehow took care of what I call the lesser penalties. So I am suggesting, and I've had an amendment drawn up, that would say that a person who is charged with a felony or Class A misdemeanor offense for any of the following, and then it repeats the list of laws just the way it is in the current bill. In what those words, charged with a felony or Class A misdemeanor offense for any of the following does, is that it includes the underlying things in the various crimes that do not have any jail time involved in that. So it eliminates Class B misdemeanors and violations. So I thought that something like that might be more amenable. And I have an amendment with that. I don't know whether it'll be allowed or not. Thank you.
Does everyone have a copy of Representative Abbas's amendment? Yeah, it does. It's 1468H.
And
It's 1486.
Oh, pardon my dyslexia.
Mr. Chair,
Representative Newman?
you weren't here for the discussion. And the discussion I had, I'll give you the thumbnail version.
I could hear the discussion.
You could hear it, okay. So I said that I had also had amendment drawn up to support if it was allowed, and I do have an amendment. And if you would allow me to distribute a copy, I would, but that's up to you. Thank you.
Oh, of course. Representative Bordenay.
There's plenty of them here somewhere.
There's some additional copies on the table.
Did I get that right?
Yes, and just to clarify, the last fall we had a bill. It was Senate Bill 92, and that was amendment. We passed that with a positive recommendation of this committee. It had an amendment number 2180. The amendment 1486. It's very similar to that. There are two changes, and that is it, at least as it's written right now. One of the changes is if there's a list of offenses, on page 2, lines 1 through 20. Out of those offenses listed in that section, the felony use of a firearm was removed, and the rationale for that was, as written, is that, and at least the policy here is that these often involves crimes against a person. The way the RSA is written today, the crime as it can be charged is a person's merely committing a crime that happens to be in possession of a firearm. However, the firearm is unrelated to the actual criminal act. And if you look in our book of RSAs, this fancy purple book, I looked at some of the cases cited under that RSA. One of them was a person was arrested with possession with intent to distribute, but because that person was also carrying a firearm, they were charged with the felony use of a firearm as well, even though that firearm did not actually play a role in that offense. Now, there's a federal law, which is not, it has similar language to the RSA in New Hampshire, and the federal courts have interpreted that the firearm actually has to relate to the offense. However, the law in New Hampshire, at least the way the courts have been ruling, have not interpreted that way. So the reason why it's been removed is that it's could be applied where so one of the issues is, and the other part of it is, if you use a firearm to commit robbery, or if you point a firearm at someone, you're going to fall under one of the other felony charges on this list anyway. So I was confident with that. By removing that, we would still be honoring what at least the intent of what it was to list these offenses.
And what line was that, Mr. Chairman?
It's page 2, lines 1 through 20 is where the offenses are all listed. And then the other change is there was a section where if you keep missing or not showing up at subsequent court hearings, the amended version, it shortened the look back period of how long they would look back from 5 years to 3. However, there was a lot of opposition to that. Although I don't agree that I prefer the amended version from amendment number 2180. I prefer that over this. I took that section out, so what appears on the amendment is what exists in law is today. You hear the term rebuttable presumption, rebuttable presumption, rebuttable presumption. The existing law has the language rebuttable presumption already in it, but that section would not be changed by the amendment that's being passed around today. That's amendment number 1486. So whatever you see there is the current law. And that's part of a compromise with some of the members of this committee that I've spoken with about that. So those are the two differences. The rest of it is similar. And then we have a side-by-side that kind of gives us a rundown of, it doesn't include this amendment 1486, but it does have the 2180 in there. Representative Testament.
I'll probably support these, but we're stepping around and going into contortions because we've got a system that doesn't work with the bail bondsmen and bailiffs. And until we get rid of that and go to either the judges or magistrate, whatever is proper, we're not going to settle this thing. I am just so irritated at trying to step around the crap to do this.
We're at the point of time where we convert to a magistrate system, and I would support that system. Now we have to put it all together. It also has to be financed. So it's not as easy as just there was some talk of even trying to put that system into as part of an amendment to Senate Bill 294. My hesitation is, one, for us to collectively understand that the complicated process that is bail. There's still issues with interpretation of an amendment that we've had, I don't know, 5-6 work sessions on, long hearings on. I think including that into this system, I thought it would have been difficult to get us all collectively on board to understand how to incorporate that into the system. But I know that there's going to be a push for that. I wouldn't be surprised if it was in the first year of next term. But to do it right now, just this late in the process, might be difficult. And by the time it's even up and running, I mean, if we don't have the funding, we didn't put fund for it in the budget in HB2. So without the funding for it, it's never going to get off the ground anyway. But it's something that's kind of getting support from all parties. Representative Marston.
Thank you, Mr. Chairman. Help me out a little bit, if you will. I spoke last night with the chief of police in Manchester, who I happened to run across, and he was telling me he's in support of the Senate bill. And it's a 4-digit number that I think Bradley put out, has to do with bail reform. And is this in that conjunction? I mean, I'm confused between these two. This talks about releasing a defendant pre-trial. Isn't that bail reform? That's why I'm confused. Thank you.
Well, all right. I don't know what specific bill everyone was talking about in that conversation. This is not, when we say bail reform, it doesn't mean if a person gets arrested, they're just going to be held awaiting trial no matter what. There's still going to be a bail process. There was, we all know there was bail reform was passed a few years ago. This is trying to really address the most egregious circumstances. We're always going to have situations where, you know, you hear about these stories and then you see the news. One that always stuck out to me, and it was an unfortunate situation. Someone was arrested 5 times in a 2-month time period for drunk driving. That I think we, without knowing the details of each of those arrests, to me it was pretty clear that person was, I made the presumption that person was struggling with something else going on. To get arrested that many times in that short of a time period, that person was becoming a danger to themselves and to the public. And I got a phone call about what are we going to do to try to address that. And they were talking about penalties for drunk driving. That's if the person's found guilty. But until you're found guilty, each arrest was for a first offense. The issue was how many times was that person going to get bail before we did something to try to help the person. The way this is written, and if you look at, it's on page 3, lines 14 to 27. On the amendment or the bill? The amendment. Page 3, lines 14 to 27. And that's in that situation, on the 3rd offense, that person would have likely been held. Now, they would have had the opportunity to rebut the presumption that they would not violate the conditions of their release, which was don't get arrested for a new offense. They would have had the opportunity to do that, and perhaps they could have overcome that. I suppose if they were arrested then a 4th time, it would have been much more difficult to overcome that. This has drunk driving, Class A misdemeanors, and felonies. It excludes the Class B misdemeanors. The rationale is if you would not go to serve any jail time as a potential penalty, should that be an appropriate reason to have to be held? The argument is that you're still violating the conditions of your release, but that wouldn't count as one of the violations of that. So we're
Would you
trying
just
to address
repeat the line number?
lines 14 to 27 on page 3 of the amendment. So if I can direct everyone's attention to page 2, lines 1 through 20, if you see the list of offenses, a lot of people have brought up that includes misdemeanors. The misdemeanors that are included is stalking and domestic violence. Just to point that out. And I guess my question is does anyone have is that a holdup for anyone? Is that a concern that someone has? Representative Ray Newman?
Well, let me address this part of it first. I was going to ask something about your third offense, but I'll go back to that. So I do have a concern, and I've voiced it many times along with all the other stuff. So, but for the other stuff is not important to me, but not catching the lower offenses is important to me. So I have an amendment that's drawn up. Everybody's got a copy of it. It has two changes. One is to change it to 36 hours, and that's in your amendment. Somewhere in there, 36 hours. Even if the number's there, I'm happy with that. And the only other change is to the first sentence of the list of crimes that are included in this. It currently reads, a person who is charged with murder or any of the following is how it currently exists. The language that I have had inserted says, a person who is charged with a felony or a Class A misdemeanor offense for any of the... Did I read that? Wait a minute, I got the wrong thing here.
Representative Newman, if I can ask a
Yes.
question. So what I'm asking for right now, at least what's
Okay.
proposed in the amendment that's passed around, I'm
Okay.
talking about 1486. The list of offenses has two types of misdemeanors, stalking and domestic violence. And I'm asking, is there anyone in this that's sitting on this committee today that is the holdup on supporting this? And the reason why I'm asking the question is if my goal is that we work together on this and put something out that we all, at least as much of us as possible, can agree on. But if to me, that's a real tough pill to swallow. I struggle with the concept of removing domestic violence from this list. I really do. But if I'm going to make that concession, I would expect this to pass with an overwhelming support in the committee. If it's not, I would be less inclined to make that.
Can I?
Representative Newman?
Yeah, so, and I didn't read the entire list of the included ones under domestic violence. That's the sensitive one, I think. Is there any charge in the domestic violence bill, the way it's listed here, that the penalty would be a violation or a Class B misdemeanor? Because that's the essence of the change I would like to see, which says that when you consider any of these laws, it has to have a penalty of a Class A misdemeanor or offense for any of the following. So it would exclude all of the little crimes, wherever they happen to be in these bills, if it's a violation or a Class B misdemeanor, because it does include Class A misdemeanors under all of those laws. I'm just trying to get to the same place you are.
Well, I think you're mixing and matching the sections. When you're talking about if you keep getting arrested for subsequent offenses after being released, that does not necessarily have to invoke domestic violence. With this section I'm talking page 2, 1 through 20, that has to, if you are arrested for any of those offenses, you will be held and brought before a judge. You would not be brought before a bail commissioner. That's all that it's doing. At that point, the state would have the option, or the prosecutor can ask that the person be detained. The prosecutor would have to demonstrate by clear and convincing evidence that the person is a threat to themselves or someone else. The rationale for keeping misdemeanor domestic violence is that it's an offense that's often repeated. And if the person has several prior arrests for misdemeanor domestic violence, just because it's not amounting to a felony does not mean that the person is not committing a violent crime against a household member or a family member or someone they're in a relationship with.
So I just wanted to ask a semantic question of you. You just said a misdemeanor. You didn't distinguish between A and B. So the term misdemeanor includes Class B misdemeanors. And is that correct, what you just said?
It doesn't list Class B misdemeanors. It doesn't say that. It doesn't even say misdemeanor here. I'm just saying it lists the RSA, so 631:2-B.
But it has penalties.
And I'm getting there.
Okay.
I'm not aware of it being a Class B misdemeanor. So they're all Class A's. Okay.
they're all, and that's all I'm saying. I'll find the one with the, I just don't want, whatever. Thank you.
Representative Rhodes?
Thank you, Mr. Chairman. So I have a question for Representative Newman. And so you, Representative, you had mentioned, and there was some discussion after that, so I'm trying to go back and remember it. You had mentioned that in other, I think you said miscellaneous or non-serious. I don't know your exact words, and I don't want to misquote you. That you said are throughout this legislation. Can you give me an example of something that you mean? I think that was less than.
I haven't done, I can't go back off the top of my head and figure all that out. Given some time, I could find out if there are any.
Because my understanding is that it basically, that the whole bill is talking about these serious crimes that we all keep on saying that we all do believe that need to be taken more seriously, which is why this bill is in front of us. So I'm trying to understand what your thought is on less serious, but I don't want to put words in your mouth or assume something that you're saying that you're not.
I will try to find an answer to your question.
Okay, thank you.
Thank you.
I believe we have someone from the Attorney General's office here today that can maybe offer some comment if he doesn't mind.
Thank you, Mr. Chair. Just as to Representative Newman's question about the difference between the Class A and whether or not there's any Class B misdemeanors encompassed within this list, with respect to domestic violence under 631-2B, the statute says clearly in paragraph 2 that domestic violence is a Class A misdemeanor unless there's a deadly weapon used, and then it can become a felony. And with respect to stalking, 633-3A, under paragraph 6B of that statute, it says very specifically stalking is a Class A misdemeanor. It can become a felony if it's a subsequent offense, but in the first instance, it's a Class A misdemeanor. So for both of those statutes that are cited make clear that those crimes are Class A misdemeanors. And there's no mention of Class B misdemeanor variants of those offenses within the statutes that delineate what the crime is.
Representative Roy?
A question of the representative of the Attorney General's office. Do you have a copy of the amendment we're discussing in front of you?
I do.
Could you look through page 2, paragraph 1, lines 1 through 20? Are there any offenses in there listed that are not at least a Class A misdemeanor?
Again, what I had just done was focused on those two as they were referenced, domestic violence but first degree assault's a felony, second degree assault's a felony, aggravated felonious sexual assault and felonious sexual assault are felonies, kidnapping's a felony. We talked about stalking. I am almost certain trafficking in persons is a felony, but I would double check that just because I don't deal with it often. Robbery is a felony, child sex abuse images are felonies, and so are 649B crimes.
Thank you.
Representative Welch?
To answer your earlier question, which was quite a while ago, domestic violence and stalking should definitely be on that list, because domestic violence, no matter what the occasion is a very emotional thing. And the emotion dies after a period of time. And if they're released out on bail, it'll just be a repeat, and it could be a fatal one.
I agree with you 100%, Representative Welch. And domestic violence is a crime that tends to escalate. It's when it's repeated, it goes up, not down. The only suggestion I was making was if that's the only hangup of keeping us divided and not perhaps keeping this off consent, it's a concession worth discussing. But if there are members of the committee that, when someone's asking to take those out and they're still not going to support it, I'm not really sure why I would make that concession. So I'm trying to ask if that's the only holdup, and I haven't got an explanation on that. It also may create some problems for some other members of the committee if we do take it out. So maybe that's I have the person to my right shaking their head one way or another. So Representative Bourdonnais? Thank you, Mr. Chair. And Mr. Ward, under current law, are all these crimes could be considered serious safety to the public and themselves? And can that not be interpreted to be required to be detained?
I guess I'm not sure, and I apologize that I followed the question. I mean, there's certainly a list of serious crimes. Under the law, would they be considered serious crimes? The law doesn't define serious crimes, so I don't know that the term serious crimes. So again, sorry, I apologize. I just don't know that I follow the question.
They're basically crimes that would be endanger the public or themselves. That is how the current law is worded. And domestic violence and stalking, wouldn't they not be considered a danger to others?
Certainly.
And wouldn't that not be a reason to be detained until they get in front of a judge?
Yeah, but if the question is whether or not it makes sense to include those crimes in the list of the other crimes that exist here, it certainly does, based on the dangers that can be posed to individuals based on domestic violence and stalking crimes.
So the question is, do this list of crimes, do they actually enhance the law, or are they a restatement of present law? Because current law already requires that if a person is a danger to the public or a danger to themselves, that they may be detained until they are and get a hearing in front of a judge.
There are certain circumstances, again, under current laws, I think has been discussed, where individuals can be detained. Yes.
All right. Thank you.
Representative Marston.
Thank you, Mr. Chairman. My question to the chair and to the
Representative Marston, if you don't mind, I'm going to recognize Representative Burt to ask a question to the witness as well while he's sitting there.
Thank you, Mr. Chairman. Thank you for taking my question. To follow up on Representative Bourdonnais' question, so if somebody commits one of these crimes under current law today, they could be held, but they're being released for whatever reason, but they could be held.
Correct.
Held.
Follow up?
Yeah. When you say held, are you referring held in pretrial detention or held awaiting a bail hearing before a judge?
They could be held, to see a judge.
So as I think has been described during the testimony about this bill, is oftentimes when that first visit is with the bail commissioner, they are not held. If your question is, could they be held? Sure, they could be.
So Manchester, where most of this problem is, they could hold these people that are on this list in the amendment currently, but they are not holding them.
They can be under the current bill, depending on, again, the factual circumstances of the case. A judge can order someone detained. Yes.
All right. Thank you.
Did anyone else have a question for Representative Conley?
Thank you, Mr. Chairman, and thank you for taking the question. Can you describe not what can happen, but what does typically happen in cases in which someone is charged with crimes included on this list that I think we all agree are serious? Is that individual typically released after seeing a bail commissioner? Is that what happens more often than not in this state?
So, the cases my office deals with, the cases I prosecute are, for the most part, murder cases, first and second degree murder cases. So, my experience is not presently, and I've practiced it as a county attorney as well, but presently with these crimes. So I would hesitate to venture a guess with respect to that, and would refer you back to the testimony you've heard from law enforcement officers when I've been here on prior situations, or prior hearings, excuse me. And there's been testimony on this bill, and certainly the testimony I've heard, I can tell you, has been consistent with your statement.
Thank you. And if I may ask a quick follow-up.
You're so recognized.
Thank you. Can you remind me, does your office have a position on the broader 294, not necessarily the amendments, but is your office in support of the concept of SB 294?
Yes, yes, and I think last time when I testified here, said we were generally in support of this bill, and we had provided feedback on technical corrections that are encompassed within Representative Abbas's amendment here, most specifically the new language to lines 1 and 2 of page 2.
Thank you.
Representative Welch.
Thank you, Mr. Chairman. On the news this morning, there was a report about Chief Maloney in Greenland, not Manchester, who was killed responding to a domestic violence incident. That's why I think that should stay in the bill, and I'll support it.
And I know that my friend from Goffstown keeps mentioning Manchester, but this is a problem throughout the entire state. Now, some communities have a higher population. Perhaps the frequency of when this would apply may play an effect on different communities, but domestic violence isn't a Manchester problem. It's a statewide problem. So I think I understand the point that you're making, that you keep saying Manchester. I'm not clear that anyone I know there was a police officer in Manchester that spoke here, but we've had witnesses from all different parts of the state, not just Manchester, in support of this. You may respond.
Yeah, thank you. I wasn't referring to domestic violence. What I was referring to is that this is a Manchester problem. There is other problems throughout the state. Absolutely. There's issues out there. But these bills are being brought forward, especially Representative Ross Berry's bill. It was brought forward because of Manchester. There's no secret. I mean, we can say what we want, but yes, Dover has problems, Rochester has problems, but the majority of it is in Manchester. And what my comment to the Attorney General was, had nothing to do with domestic violence. It was the bill itself.
Representative Marston.
Thank you, Mr. Chairman. My question to you, because this amendment is yours, does this replace the whole bill?
It is a replacement of what was the original bill of 294.
It replaces the 294.
Some of it's similar, but in an effort to follow along and reference pages and line numbers, without doing the complete replacement, it was very difficult to navigate between the two documents. So that's why I requested it this way.
Okay, thank you.
Representative Testament.
Thank you. I know this appears to be a Manchester problem. Manchester has 100 and so many thousand people. I live in a city of 8,000. We have exactly the same problem that's described here. So it's not just Manchester. We have the same nuts running the streets.
Representative Conley.
Thank you, Mr. Chairman. And not to hijack this, but there is another amendment that's coming. So I'll be the first to say that I support the amendment that you drafted. There is another option, depending on what happens with that does a few important things that I just want to outline. It just strips the amendment down to the first section. So it's only about making sure people accused of quote unquote serious crimes have to go before a judge who would then determine bail. So there's different bites at this apple, and it delays the start date until the start of the next fiscal year. We've heard a ton of concern about how do we pay for this $2 million. Not sure. I think we could figure that out, but that gets rid of this concern. I do support the amendment. I think it's important, but there are other options that could be considered, and I hope that that's known. And that amendment isn't done yet for reasons that are out of my control, but it is coming.
And our friend from the court is here, and he unfortunately has to often say the same thing. He often discusses the effective date in a lot of bills, and a lot of times we should try to do our best to, whether they support a bill or not, the effective date's important. My understanding was although without supporting the rest of the bill, it was preferred to have the effective date on the January 1st of a calendar year. So by putting it out in, well, July 1st or whatever, would that be a problem for the court?
With regard to the effective date, July 1 is the sort of minimum effective date bump. That's the one that's set in the statute. As Representative Conley said, if we can, our issue and our concern about this bill has always been one of fiscal impact, especially on the circuit court. And as Representative Conley said, if we moved the effective date till July 1, after we've gone through the budget cycle, we will then have a process by which we will have determined the budget, hopefully incorporated the budgetary needs that we would see as a result of this bill, and that would be in place by the time this became effective. Yes, there would be transition, but at least we would know where we are relative to the budgetary impacts. So we do support if there is an amendment that would move the effective date to July 1 as opposed to January 1. That does accomplish the need that, from our perspective, of being able to then have the budget conversation with the relevant committees.
Does any other members have any comment on or opinion on the effective date? Is that a holdup for anyone? I guess that's the other. I think what's you're saying makes sense, Representative Conley, and I understand the comments from Richard had. I guess my only concern is that's over a year from now. I understand that's how the budget system works. That's how it plays out. But to put this into place, I mean, if there are vacancies in the court right now, whether this passes or not, I would still support filling those vacancies. And please correct me if I'm saying anything that's not accurate. If there's 5-6 vacancies in the circuit court, I would support filling those with passed regardless of this bill amendment, all that. So I guess for me, like that put it as a holdup. I'm not sure we should delay it any longer than we have to, but it's just my opinion.
May I? So I agree. It is strange to legislate something a year out. So one follow-up to that is this already wouldn't take effect until the first of the year. So there already is a pretty long lead in. And we've heard we've heard comments from people who will vote on this that the cost of implementing such a program is a holdup for them. I support this concept and I want to get it through, particularly the first part. And I don't want to see this whole thing blow up because of little things like that. And if we're talking about paying for it and that being a holdup, let's get that out of the equation, get it implemented, and start it a little later. And hopefully in the meantime, judges who, I mean, we've heard repeatedly that the current law already lets judges do what the bill would do. Maybe they'll read the writing on the wall and start enforcing the law a little bit better.
So if I can just ask, this is open for anyone on the committee, is the effective date, whether it's January 1st or I'll just say July 1st of 2023, is that a holdup for anyone? Representative Espitia.
Well, I wanted to comment and say, I think, if we were to wait till next session, then you would be delaying it even further out. We wouldn't be able to put in a system by June 20. If we put a new LSR in and have to go through the whole legislative process, that would probably be pushed out to 2024 at the soonest. So, by us not doing this now, because it's gonna take, it's gonna take too long. you're inevitably just making it prolonging the process, and then we'll have to wait another year and start the whole the whole process all over again. So I think the effective date of June 2023 would just help us move along and actually try to get something in place, because we're hearing that one of the issues is that we're just seeing bottlenecks and people are being, it's just so much confusion in the system. So, and people are being held, and so I think this would be helpful.
Representative Bourdonnais? 2025. It's not a bad strategy. Representative Burt?
It's nothing to do with what we're talking about. I do have a question for Richard Head, if I could, Mr. Head. Okay.
You may ask the
All right,
question.
thank you. Again, what's a red flag to this bill to me? One of them is that the LBA does not ask for a fiscal note on it, but you said it was similar, it could be similar to Senate Bill 92, which I believe was about $2 million.
If I could just talk to that, we did have the conversation with the LBA.
Oh.
And they have now issued a fiscal note that does incorporate our fiscal note. So in response to the hearing, I did have a conversation with Mike Hoffman. They just simply missed that there was an impact on us. I gave them a proposed worksheet, and that's now been incorporated. My understanding was that had been circulated to the committee, but apparently not.
No,
it is essentially the same fiscal impact that you saw in 92.
And is that 2 million?
Exactly, yeah.
It has been emailed to the committee. In respect to the fiscal note, I know we've all heard this, and we've heard other committees say it. The policy, the issue of the fiscal note, that is for finance. So if this were to pass, my understanding that this bill would then have to go through the finance committee where that would be discussed. Now, does that mean you completely ignore any type of fiscal impact? I think that's not I'm not saying to do that, but understand that the fiscal impact will have its own argument on its own merits.
Well, and if I could finish?
Yes.
Yes, thank you. And what is a magistrate system? I understand it's around $1 million. So could we take this bill, turn this into a magistrate system, June 1st or whatever that date is bouncing around, get this rolling, and hopefully in 6 months after June 1st, we have something in place that would work?
So we've at least very preliminarily discussed internally probably having 12 magistrates that would work statewide. The bail would be an electronic bail conversation with local police. So it'd be telephonic or video. Our estimate, again, preliminary, would be roughly $1 million if that was the system. One of the things we've talked about since I ran those numbers is potentially having a per diem system where some of the current where we would essentially have a potential transition period also, that we would do a per diem with some of the bail commissioners that would then become under our control as employees and sort of transition that way. But roughly, if we were just talking the magistrates and we had 12, it would be initial calculations around $1 million. That's correct.
Yeah. And just one final question, if I can. Yeah, thank you. I'm not sure when that email was sent, if it was sent while we're here.
I think the day yesterday, I think.
Okay, I missed it then.
You only get about 500 emails a day.
That $2 million that you speak of in Senate Bill 294, does that include the county cost of the flood of people possibly that is going to end up in the Hillsborough County Corrections, for 3 to 4 days, whatever it is, or up to 36 hours?
No, we explicitly identified that as something we were not including in our cost estimate. Same with public defenders and the additional cost on public defenders, if there is any.
All right, thank you.
And in respect to a magistrate system, having the policy of having magistrates as opposed to bail commissioners, That's one policy. Then the procedure for bail is its own separate policy. So what we're talking about now is the procedure for bail. All right. So simply having a magistrate system doesn't necessarily, I would say, resolve our differences here. It's replacing the concept of one with the other. One issue that it would resolve, the only issue I think it really does resolve is the issues of the weekend. Some people have some objection that a person can be held for an extended period of time because the time period excludes weekends and holidays. If you were to have a magistrate system, it would not be a tremendous burden to have them operate on the weekend as well. But that problem, the issues of the weekends and holidays, is a problem under existing law as well. So we face that now, whether this bill passes or not, that weekend and holidays. And if you notice, at least when I've done a lot of the amendments, I've been, rather than have 72 hours, then excluding weekends and holidays, I've been kind of moving that down to 24 to 36. And that's because I have an issue kind of with the weekend problem as well. But that's how the system is. We can't fix that in one day.
And Mr. Chairman, if I could just, to make sure I understood, what the concept would be that we've been discussing in the magistrates is it would replace bail commissioners. So the magistrates would take over the bail duties along with judges also doing some of it. The magistrates would be available 24/7, weekends, holidays, nights. So just to make sure I understood your comment, it would replace bail commissioners and be a 24/7 process.
And if I just may ask a question, we did have another work session scheduled for Senate Bill 292 that was scheduled for 11:30. Is there any members of the public present for that bill? All right, well, we'll keep going with what we're doing. Representative Ray Newman.
Thank you, Mr. Chair. In previous testimony before this particular one right here today, you mentioned the impact that of 2,800 and X number of cases would cause. At that time, I was under the impression that bail commissioners only operated on off hours of the court. So I called Nashua. I know we don't want to do individual places, but this is all I could do today. I called the Nashua Police Department to ask them to run me through the process. We get to the very end, they said they use bail commissioners, and I said, so when do they see a judge? Well, in Nashua, they use bail commissioners almost exclusively. So with that new knowledge, does that affect the cost it would have on the court if we all of a sudden with this bill could not use bail commissioners again? Would that affect whatever your previous testimony?
Truthfully, I may be misunderstanding the question, and I apologize if I am. What we had looked at were everything under the list of crimes. So we're still not talking about the second and third arrest provisions of the bill, but just in the first section with the list of crimes, we identified how many of those that are currently being arrested that have not resulted in a detention hearing. So essentially, which ones are currently going through bail commissioners and which ones are currently going to a judge for a bail decision. And we had identified, and I'm not going to get the number exactly right, but roughly 3,000. So we identified that as being within just that first section of the bill, the number of previous current system that do not have detention bail hearings that would now be brought before a court and have a detention hearing, and based on that identified the number of additional hearings that would be held in circuit or superior court.
Follow up, Mr. Chair.
Recognized for a follow-up.
Yeah, and I'm just trying to make sure I understand your calculations. I since have learned and went through the list and found that there were not any misdemeanor B offenses in any of those laws.
But there are, as Jeff Ward mentioned, there are some misdemeanor A's. Those are circuit court processes.
Thank you.
If I may inquire with the question, so the exact number I believe was just under, it was around 28.
2,900.
So we'll just say 2,900. If there's we'll just assume that there's 104 days that are weekends. We're going on a limb there. And then we have, let's just say 20 recognized holidays. I haven't done the math for that either. So we'll look, my math, it came to about 11.8 hearings per day throughout the entire state. Now, I understand the majority of those may be in, I think it was at Rochester, Concord, Manchester, and Nashua. We don't know which percentage, the exact amount that goes into those, but we're talking about, it's fair to say, less than 12 hearings a day on average. If we distribute that throughout the state, they're about 5.8 minutes per hearing on average. That's the time it would take for these bail hearings to be performed.
So to if I can just sort of follow up on that, what we had identified was roughly within the system, we would have to incorporate, I don't have the note right in front of me, about 6.5 weeks of hearing time that would have to be brought into the system. The majority of those are in the 4 courts you mentioned. If we're only talking about judge time and we're only talking about section 1, as opposed to also incorporating in the sections of the bill that deal with third arrests for misdemeanors and felonies, sort of adding on an additional number, which is an unknown number. We have the more concrete numbers on the first section, and then we add on top of that the far more than 5.8 minutes per case that staff have to manage. And I talked about that in my testimony last week, and I won't repeat it, but it is a significant staff staff time management issue relative to each of these hearings, which would be coming in without having gone through the bail commissioner and the paperwork that the bail commissioner does. You heard one of them talk about it takes them 2 hours. You know, what we're doing is transferring a lot of that work into the staff at each court. And that is a significant burden, far more than 5.8 minutes per.
If I can inquire, but if a person, even if they're arrested today, they go before a bail commissioner, the court still has to have a case file and have to docket that and create a file. I mean, don't they not? So I guess what's the only real extra step for the court is having the hearing in front of the judge, which
I would
quite often there's normally a hearing already scheduled for other arraignments, and it's going to be added on to an existing schedule.
I disagree with that pretty strongly. What the bail commissioner one does is puts together all the initial orders, paperwork, and that then comes to the clerk as opposed to the clerk creating it. And then, as I had mentioned in my testimony, the clerk is responsible for coordinating with the county jails for each of those hearings, whether it be by video. And as I mentioned in my testimony, what we have largely done in a number of counties is used up all of the video time available in a jail. So instead, staff is coordinating with county sheriffs and the jails to arrange for a transport at the right time and place in the courthouse, and then has to manage all, essentially from scratch, all the paperwork that the bail commissioner would have put together in court. So I pretty strongly disagree with it's just a judge time. It's actually a far greater burden on staff probably than the judge.
Thank you for clarifying that. Representative Testament, then Representative Conley.
Thanks for taking my question.
Mr. Chairman, I apologize. Can I just ask, Karen Gorham is with me today. She has greater knowledge about a lot of these details, and if she can join me, that would be helpful.
Of course.
Thank you.
That's why there's 2 seats there.
I know, she's probably saying he said so many things. That are
I saw her shaking her head, and I'm just saying,
That's a fair point.
I'm glad she's not sitting next to you. No,
Affirmatively. You saw me shaking my head affirmatively.
in a polite manner, of course.
I have a question. You gave testimony, and maybe I didn't understand it. One of the real issues that were we have these bills, or this bill, is because a lot of people are released out on the streets again and again. And, you know, the intent of possibly having a magistrate there would and because he has some judge capabilities. Are we doing anything that's really going to keep us from releasing this if we don't pass this bill as is? It has a list of, you got to look at these and look at these seriously with a judge. I mean, I got the impression that all we did was replace the bail folks with magistrates, and we got the same old happening again.
If I may respond? Good morning. My name is Karen Gorham. I'm the Superior Court Administrator. And I have been here for this entire work session and heard what was being talked about. If I may, before I answer your question, Representative, just go back and talk for a minute about incarcerated versus non-incarcerated arraignments and the way we handle them in Superior Court. So as you know, most of the charges listed in paragraph 1 on page 2 are felony offenses. There are 2 that could be misdemeanors. When a defendant is arrested on a felony, they see a bail commissioner, and as you've heard in prior testimony, most often those defendants are released. That results in a non-incarcerated arraignment. We hold large non-incarcerated arraignment sessions, and when the public defender and the county attorney are there, more often than not, those cases result in an agreement, and the clerk of court takes the paperwork, a judge signs off on that without a hearing being held. So it's a session without a judge on the bench where everyone comes into the courtroom. So we're not taking up any judge time for those defendants who have been released, and if they show up, there's usually an agreement between the parties for them to stay out on bail. Occasionally, the prosecutor may want to have a bail hearing, in which case it would go in front of the judge, but that's fairly rare under our current system. By taking this list of offenses and saying they shall be detained, meaning they won't see the bail commissioner in the first instance, resulting in an incarcerated arraignment, the process in Superior Court is we hold those arraignments. Some courts do them at noon, others do them at 1 or 1:30. We find out in the morning that someone has been detained overnight and needs to be scheduled for an arraignment. That means the county attorney has to file the complaints in that case. Our clerk's office has to get all of the paperwork to the public defender's office because they usually will appoint for incarcerated arraignments, and then schedule that hearing. Currently, because they're usually done by video as a result of COVID and the pandemic, I was in a meeting yesterday with a judge from Hills North and another one from Hills South. It took them 3 hours from 11 o'clock to 2 o'clock to handle 4 arraignments because of problems with the jail. So I think we are going to go back to transporting those individuals to the court. When the number of incarcerated arraignments increase, the impact that has on the superior courts is fairly significant in the instance of, our judges do jury trials. We currently have a backlog. We're trying to pump out as many jury trials as we can to help get rid of that backlog. They then have to take a break, excuse the jury until sometimes 2 o'clock in the afternoon so they can handle those last-minute incarcerated arraignments. So there is an impact and a huge difference between the non-incarcerateds and the incarcerateds. Under this bill, it would increase the number of incarcerated arraignments that we have. Having the resources to conduct those hearings without interrupting other court business is very important from my position as the Superior Court Administrator. Magistrates, under what we are talking about as magistrates, would be, they do set bail in the first instance. Under this law, if someone shall be detained, a magistrate won't have to be contacted to set bail because they shall be detained, but they can also handle those arraignments. They will have the ability to conduct the arraignments instead of having the judges conduct those arraignments, and that is a very, very important piece of our thought with the magistrate bill, is that they do set the bail, and on those cases where someone is eligible for bail, those would be court employees who are trained on setting bail, and we would know what they were doing and who was available to handle the bail setting. They would then still go in front of a judge for an arraignment. If it's an incarcerated arraignment, the magistrates can step in and handle those in the middle of the day. So there's a significant impact with the magistrate system and how it coincides with the bail law. And I think Richard did touch on this. You know, it's not only that first paragraph with the mandatory detentions for 72 hours, it's also the repeat offenders and those who are currently out on bail who may reoffend that will also be detained, increasing the number of those incarcerated arraignments. I hope I've answered your question. I know that was very long-winded, and I apologize.
Representative Conley?
Thank you. You did answer, I think the question, or as I understood it, the question raised by Representative Testerman, because I had the same question, but could a magistrate system coexist with a system that requires bail and still and essentially send some people to a magistrate to lighten the load, but require more people accused of violent crimes to come before an official judge? Like, would these exist in the way that I think the court system wants?
Yes.
Okay, and
Yes.
if I may follow up.
Recognize for a follow-up.
Thank you. I've heard a lot about magistrate for the last few months. I've not seen a single bill or amendment. Does one exist, or are we talking about a concept 2/3 of the way through a term that can't necessarily get acted upon this term?
So I can speak. I do have a draft I'm happy to share with the committee, a draft bill, and I can distribute that today if you want it.
Thank you.
If you could possibly email it to myself, I think I might have a copy of it, but if just make sure we're on the
Happy to.
send it out. I'll have it printed out for the members of the committee. Representative Harry Gathright?
I have an amendment coming later, and it actually is the same draft that was presented by Mr. Head.
Is it in regards to the magistrate?
Yes, it is. Absolutely.
And if we did, now just to point this out, if we were to have a magistrate system put into place that were to then replace what was Senate Bill 94, I would want to, before we do anything with that, I would want to confirm whether that's a germane amendment. It's on the issue of bail. I get that, but we are completely replacing the system of, we would essentially be repealing any bail commissioner law that's on the books right now. So I would want to confirm that. And if it's not ruled, if it's deemed not germane, all we have to do is have a public hearing on that and separate and notice it. So I would want to confirm that before we do even consider that.
Okay. Question to the chair. Would what's his name, Anthony over there? Would he know if that's germane? No?
That's decided by the Speaker of the House.
Okay.
My only other comment that I would make is when it's a non-germane amendment, we could do that with any, but by the nature of what it is, it's not germane. We could do that with any existing bill. So my question is, if we put in a magistrate system, we still got to come up with the bail policy that would work with that magistrate system and then agree on that. So you can take the policy that's set forth in Senate Bill, at least it's the amendment to Senate Bill 294. You may not agree with the policy in there, but you may agree with the magistrate system. So there is a benefit of also having them separate. I mean, if we can't even agree on the policy here, I gave my opinion on what I think it's a good system. I am supportive of converting to that system, but in the meantime, I'm just not sure we're going to do it. So, Representative Bourdonnais?
Thank you, Mr. Chair. So are you aware that the House has passed a Bill 1476, and it deals with repeat offenders? Or do you, if this becomes law, are you going to see an impact on the judicial system today?
So, yeah, so we did provide testimony on that. That bill would address, covers, it's very broad, covers felonies, Class A and Class B misdemeanors, Class A and Class B separately, and would prohibit PR bail. So would have a significant impact on the court system from a fiscal perspective. That's correct.
Would it have as big as impact as this bill would have?
It's actually somewhat broader than this bill, so probably well, in some ways it's broader in this, especially when we're focused on Section 1, which has a list of crimes as
No, it
opposed
doesn't have, no, that's not
of
1476.
I'm sorry?
That's not 1476. It doesn't have a list of crimes.
I understand. I'm sorry. I wasn't clear. 294 has a list of crimes. The House bill does not, covers all felonies, Class A and Class B misdemeanors, so it's much broader.
And let me just clarify, because you're referencing HB 1476. That the application of the policy in that bill, when it would apply is if someone gets arrested while out on bail, they are then, that policy, that person would simply be brought before a judge, not a bail commissioner. That's what that would do. I know there was an amendment to it, but that's the only application that would have. The list of crimes we have here specifically has to do, you don't necessarily have to be on bail. The nature of those crimes are, as I said before, violent offenses. So in that scenario, you're not violating the conditions of your release. You could have no criminal record at all, but if you are charged with one of those offenses listed on page 2, lines 1 through 20, those, if you're charged with one of those, it's similar in philosophy, you would be held, brought before a judge, but they're very different in the procedure and application. Does that make sense? There's a difference between violating the conditions of one's release or the conditions of their bail and a person not being on bail and being arrested for the first time. Does that make any sense?
I guess maybe I'm don't understand what I'm listening to. In 1476, we left the language for detention in the present law, which is a danger to themselves or a danger to the public safety. What we did change is the ability to detain people for repeated crimes. And that is what I am questioning, whether or not that is going to have a major impact on the judicial system.
Yeah, so the answer is, in terms of impact on the court system, the answer is yes. It would have a significant fiscal impact on the court system for the similar reasons that we've been discussing.
And if I may follow up, if we were to add on this particular bill as written today, which lists major crimes that also have to be in front of a judge before they can be detained, would actually add more load to the court system?
So just in terms of the bill we're talking about today, 294, page 4, lines 21 through page 5, line 2, that's has similar impacts to the House bill in the sense of this one it's the I think the third arrest. So some of those impacts from the House bill are also in this bill.
Right, I understand that.
And then on top of that, the first section is first arrest. It would be a detention hearing, so that does add on top of either the House bill or that other section of this Senate bill. That's correct.
All right, thank you.
Representative Burt, do you have a question?
Yes, I do. Thank you, Mr. Chairman. If the amendment for the magistrate did pass and, replaced 294, which I would support, how quick
have you read
could
it, Representative Burt?
I think it's being written by Representative Garthright. Yeah. So.
Yes.
Yep. So how quick would that, let's say if we set a date of June, how fast could you put that together? I'm assuming you'd have to hire staff and judges and, et cetera.
So, and Karen can follow up. I think the one would be getting through the budget process. Two would probably be within that, establishing a per diem system so we could create a transition. And then third would be, as you said, the hiring of the magistrates. That takes a bit of time. So we're probably talking in terms of hiring and getting them in place 6 months, at least to implement that phase of it.
Yep. And a follow-up, Mr. Chairman?
Representative Burt, you recognize for follow-up?
Thank you. So if that took place, we're looking, possibly January 1st, we'd have something in place to help this situation that we're having in, mainly Manchester, but also throughout the state. And those people would be under the judge's control, where is it, I kind of, if you could correct me, I'm hearing that the bail bondmen are not under the control of the judge. Is that true? And this would also be cheaper if we did it this way instead of passing 294. So I can't imagine, the fiscal or the finance would say no to this.
So just one slight correction, Representative. Bail bondsmen versus bail commissioners. There's a lot of confusion between the two. The bail bondsmen actually write the bond and provide the insurance.
I apologize. Yep.
No, which is a separate issue because we have very few in our state now after bail reform a few years ago. There was no business, so they've left the state. Hopefully they'll come back. If we build it, they will come, hopefully. The bail commissioners are responsible to the Chief Justice of the Superior Court and the Administrative Judge of the Circuit Court. They're trained and hired. The local judges do not have any control over the bail commissioners. The bail commissioners make their own independent assessments, and I believe Richard has spoken in the past about some of the issues that we've had with bail commissioners and given examples, because they're not court employees. And we are not in control of when they go out to which department and take care of the bail. So no, they are not responsible to the judges in the individual courts.
Whereas, to put the flip side of that, as magistrates, they would be court employees. They would be directly responsible to the courts and subject to discipline within the court system if appropriate.
All right. Thank you. And it's a cheaper cost.
And in terms of the overall budgetary impact, correct.
Yep. Thank you.
So if I just may inquire with the committee here, it's a couple minutes past 12 o'clock. We have members of the public here. I don't have a problem working through lunch, but I know not everyone agrees with me on that. So do any members want to, it's going to be short. I know some people are sensitive about that too, but we can break for a half hour. Is there any members of the public here that are on a time schedule that?
Well, Mr. Chairman, how much more time are we going to pound on this? I mean, I think most of us have our minds made up where we want to be.
I'm confident that you do.
Correct. Yes, I like cheap.
Well, there's other members of the public present today that are here to offer some comment as well.
Could I ask one quick question? I mean, people
I'm asking a question about, does the committee want to get lunch?
But you will.
If the answer is no, then the answer is no. I'm just asking.
Half hour.
Point of order. Point of order.
Representative Newman, you are recognized for your point of order. Please state your point of order.
My point of order is that while you are polling people for lunch, you've allowed other members to ask questions without even seeking recognition. And I've been seeking recognition and have not been recognized, so I have not said anything.
All right, I'm gonna rule on your point of order. It's within my understanding. It's within the discretion of the chair to recognize someone to ask a question. That's my ruling. If you don't like how I'm exercising my discretion, you can challenge the ruling of the chair. Back to the conversation about lunch. All right, the committee will be in recess to 12:35. I just asked them that question. So. So, have to know. People go from the bottom of their heart. Even if we talk, we have to agree on the bail. So, if we don't agree on the bail procedures, how are we gonna? At this time, we'll now reopen the work session on Senate Bill 294. All right, before we get into any other topics on E, there's a couple amendments now floating around. Are there any other questions? I know Representative O'Hearn, you had a hand up. No? Representative Newman, you have a question?
Thank you, Mr. Chairman. I was just wondering if I could address a question to the people who were testifying earlier, and it probably shouldn't take any longer than 30 seconds to ask the question.
Just ask the question.
Thank you. Thank you, Mr. Chair, and thank you for taking my question. We're talking about future things, so I like to put that aside and ask a question about this bill effectively for the number of crimes that are listed, takes away the ability of using a bail commissioner. Just with that, if we were to pass the bill and that still remained, that you could not use a bail commissioner, would it have a financial impact or on the court system?
So, if I understand, so essentially we would be removing the bail commissioners from the process and putting it into the courts. So essentially decreasing the load on bail commissioners and increasing the load on the courts. So yes.
Thank you.
Representative Mangiapudi?
Thank you, Mr. Chair. A quick question in terms of the transition, knowing what we have currently with the workforce and all that, how quickly the transition from bail to magistrate can happen, and what would be the backlog?
I'm just gonna, and this is not directed at this representative. We discussed it. We floated the idea of having a magistrate system. The amendment right now does not address a magistrate system, so I don't think we need to get into any more detail about or questions or discussion on having a magistrate system. So
Can I rephrase it and say, are we entertaining a hybrid in a transition?
the amendment that's I've seen thus far would not have a magistrate procedure in there. And this is the last time I'm going to reference this. If you had a magistrate system, there still needs to be a bail procedure in place. So what we're talking about, the policy of the procedure, that's what Senate Bill 294 is, and as well as the amendment, that's what it would cover. So I guess my question is, in regards to the amendment, do any members have any questions about anything that's in that bill right now? $1486H. The one that we've been talking about. The one that we've been talking about since 10 o'clock. Is there any questions about that amendment as written? Okay, see, no, okay, now I understand. Buzz Shear is here. Does any members have any questions that they would wish to direct specifically to Buzz Shear about any of the material in here? I'm not asking for testimony. I'm just asking, is there any questions anyone has about anything? Representative Burt.
Check.
I just turned all the mics off. Let's try turning them back on. Rep. Would stay on track. Representative Burt.
That's nice. I like that. Thank you. Thank you for coming. There's a cost of $2 million here. Are there cheaper alternatives that we could apply or go to that would get a better result?
And just remind everyone, the issue of the fiscal impact is a policy that's considered by the Finance Committee, which this bill, I would imagine, would find its way there.
Okay, I could reword it.
I'm going to ask that the questions directed towards anyone, any members of Press Shear, the fiscal impact is not what puts up a lot of people say let's keep it moving, so let's any fiscal questions. I think we understand what's possible.
Okay, I'll reword it. Currently, we're releasing people that probably shouldn't be released. The bail, who's releasing them now? It's because I want to make sure.
Bail commissioner.
Okay. I want to make sure I get the right words. So the bail commissioners are releasing people that probably shouldn't be released. Is there other alternatives instead of just this bill that would achieve a better result?
Yes. The fundamental struggle that's been going on about bail reform is a dissatisfaction amongst many stakeholders about the performance of bail commissioners. It has been erratic around the state. Some are very good, some are less than very good. The court system has made efforts to improve their training, but I think everyone recognizes that that has been very difficult and probably hasn't worked, partly because the courts, they're not technically employees of the court system. So, so people are getting released that the police don't think should be released, and people are getting held that defense lawyers don't think should be held. And it is really at the core of the issues that have bothered many stakeholders about bail reform. If one were to regularize who is an individual is seeing for the first time when they're arrested, and that person was available, or some version of that person was available 24/7, that may well take care of many of the problems that many stakeholders are complaining about as to bail reform. Because they would be employees of the court system. There would be, they could be held to task if they were going rogue, so to speak, in the nature of their rulings.
There would be an ability for individuals, be it police, lawyers, citizens, to complain directly to the court system about their performance. There'd be a regular evaluation process. It would improve that weakness in the system, that pressure point in the system at the front end of the system substantially. And, I've read the magistrate proposal that the court system has been working on for at least a year and vetting, and it would have that effect. And, practically speaking, the right way to go about this process, if one looks at the big picture, I think everyone agrees the right way to go about this process is to adopt a magistrate system, see if it cures most of the problems that we're having now with bail reform. And if it isn't, then come back with bills such as this one or other bills once we know what the problem is, now that we've plugged that weakness, now that we've made that weakness a strength. That's the best way to do things. I think I've made clear to everyone, I'm a strong advocate of that. I can see there still being a need for some bail reform, in some reform of the bail reform statute in certain circumstances after we have magistrates in place. And, I would be much more comfortable supporting that because I would know that we have grown ourselves out of that weakness. But until we do that, we don't know how many people who are held on domestic violence charges end up being acquitted or end up having their charges dropped. We don't know, and I think to be probably too blunt about it, there are very serious domestic violence cases, and there are other domestic violence cases that are overcharged. There are very serious stalking cases, and there are other very serious stalking cases and other stalking cases that are overcharged. And by what this bill does is it takes the discretion at the front end, it takes much, not all, but much of this discretion away from the judge as to sorting out the serious domestic violence cases, the serious stalking cases, and the overcharged stalking or domestic violence cases. And that's my difficulty with this bill. It uses, for those misdemeanors, it uses a categorical approach too quickly. I have no difficulty, or I have less difficulty with the non-misdemeanor portions of this bill. But the short answer is yes. If we were to put in place a magistrate system and then look at what we need to do about bail reform, because we'll have better data, we'll have more reliable stakeholder in the court system in that regard. Not that the bail commissioner system is the fault of the court system at this point. Then all of us will be in a much better position to make high quality decisions.
Yeah, my mic's, it is working.
Thank you, Mr. Chair. In the situation that you were just describing in your testimony, where you were talking about some system that would be able to probably solve some of these problems, in the period between now and if we pass this bill until that happens, is there a form of employment that perhaps a contractor or some other legal form of employment that could make that what is now a bail commissioner more accountable to the court, where they might receive better training?
I would defer to the representatives from the court system to give a firm answer of that. My belief is we already have that system. That's what bail commissioners are, and I will be as blunt as I tend always to be. I think we should get the magistrate system in place now as soon as possible to make it happen. If some mechanism were used to make that happen this session, we could be up and running with the magistrate system by January 1st of this coming year. So I don't think there's any substitute for the bail commissioner system that gets us much closer to the magistrate system in the interim.
Follow up. And I'm not sure that I agree that the contractors right now. I'm just thinking that my question was meant to ask some kind of system where they are paid by the state and they are more responsible to the state. So I just want to clarify that, and I don't know whether you agree with that or not.
I don't think so. That would probably need statutory authorization. I mean, the bail commissioners are statutorily authorized, and in fact, they have all the powers of a judge in setting bail by statute, explicitly. But they're paid, technically, whether they're contractors or not, they're paid like contractors. They're paid on a case-by-case basis.
Thank you.
Thank you, Chair. Thank you for taking my question. I won't ask you the obvious question on whether you think this bill is necessary at all. But you mentioned just a few minutes ago that if we incorporated this new judicial system, that we would have better data. More data available through the court system than we are, and
No.
with this new system, how would we get more data about what is happening?
Since I'm a law professor, I get to give at least two answers. Answer number one is technically data is available in a manual count way. I could get a list of I think I could get a list of all the domestic violence cases by case number from the court system. Is that right about that? Kind of. Could be extracted. Yeah. So, or I could get it either from the court system by case number or from the public defender system. Then I could go to the court service that allows you to give them a name and a case number, and you can get the case summary from them, and you can look at the one-page case summary about all the different things that happened in the case. But that is to do that and look at enough cases that your data would be reliable at all is just not possible. So no, the data is not available in any real sense, although in that way I just described technically it is. We could certainly make a part of the magistrate system that data be kept of the results of the magistrate court ruling in each case. That would be something of an add-on, but that could be something that we would do. I think would make sense doing as a part of a magistrate court system, because it would inform us going forward about whether we need bail reform or not. Whether, let's assume as amended, the amendment for 294 passes, fails. Let's assume it fails. we would be able to come back and say, look, here's what's happening. Too many people charged with serious domestic violence cases that are eventually getting convicted are getting out on bail or are going on and committing more domestic violence crimes. You know, we would have a better shot at getting that data to sort out whether we really need to include domestic violence or stalking on this list, the misdemeanors on the list in the amendment. So it's a kind of a long-winded answer, but there's, as you can tell, there's uncertainty at a number of levels.
I'm still uncertain about the data. Maybe I have to talk to the judicial system to see what is actually available.
Yeah, essentially nothing is available right now.
I was going to, but I think I'm done. Thank you.
Thank you, Mr. Chairman. Thanks for taking my question. You stated in your testimony earlier that a clerk magistrate system could be up and running by the 1st of January.
That's my understanding based on the court representative's testimony.
Okay, follow up, please.
I have a point of order.
I'm not talking January 2023, I'm talking January 2024.
Got it. Okay. Follow up.
The chair has ruled that talking about the magistrate is not in this discussion of the Amendment 294, and we're once again getting off track. And all the questions are referring back to the magistrate, and I would like to deal with what's in front of us, because the magistrate's not in front of us, and I don't have any idea what we're talking about.
I'm shocked to hear that happened while I wasn't in the room. I've said it once, I'm going to say it again. We're not going to discuss the policy of a magistrate system any further. It's not, in my opinion, it's not part of this amendment, and that's that. So it's not referenced in there. That's a separate policy. So if we're going to be discussing that any further, I'm just going to deem it out of order and not relevant to what we're talking about. We could have a ad hoc hearing where we can just schedule a hearing where we all meet and we just discuss the policy of a magistrate system. And I'm willing to schedule that hearing. It has to be noticed, but I would entertain that, and I would hope we have full attendance if we did. Well, we're still in the work session. So, Representative Schultz, do you have a question for?
I am hearing, thank you for taking my question. As a Concord rep, I recently overheard that our bail commissioner position is unfilled. I don't remember. I believe that's at the county level. Do you know how many how many vacancies there are? Maybe that's a better question for someone else, but.
I do not, and that is a better, Mr. Head may well have the answer to that question. I know there are unfilled bail commissioner positions.
Representative Burt, you're recognized.
This is for the chairman, a question to the chairman. The 12 years I've been here, a full committee work session is not based on one amendment that the chairman put it in. It is based on, open discussion to see what is the best result. Again, I've been here 12 years, been on many work committee sessions, and we talk about a lot of stuff. We talk about the finances. We talk about, stuff that is not in this committee. So I guess I'm just confused why we're just restricted to talk about your amendment when that's not been the case in the last 12 years. But the other is.
So you want me to answer
Yep.
that question? Do
Yep.
you have another question?
Yep. No, if you want to answer.
My understanding is all that is within the discretion of the chair If someone did not agree with the ruling of the chair, they had the opportunity to challenge the ruling of the chair. And at this time, I considering there was no challenge made, I assume that they have since waived that. And I think that in respect to the money in reference to the fiscal impact, I want to thank the members of the court for providing that to us. It's been well stated already. We're not going to get any more information on. We already know what the fiscal impact is projected to be. It's already there. To continue to keep talking about the fiscal impact over and over again is, even though it's outside the purview of this committee, it's actually still also repetitive. That's why I made that decision. And in respect to the magistrate system, if people want to talk about a different type of amendment, all we've been talking about was specifically 1486. There's Representative Conley referenced another one, but again, we're not even sure the magistrate amendment would be ruled germane. I would think that we would need to clarify that. So we're not going to talk about the magistrate system right now, and I wouldn't be inclined to consider having a non-germane hearing for a magistrate system in respect to Senate Bill 294. So when I say there's no need to talk about it in respect to 294, because as the chair of the committee, I have the discretion to consider having that non-germane hearing, and I'm not going to do that. So that's why talking about any further in respect to 294 would not be a good use of our time. Any other questions of Mr.
Well, I
Scheer?
got one last question, if I may,
Is that a question for the?
for the chair.
You may make another parliamentary inquiry.
All right. I'm not exactly sure when we started this. Now 10 o'clock, so we're 10. So we're approaching what, 3.5 hours. You know, and we're just pounding on the same issues in the bill, in the amendment. You know, I think we all know where we're going to vote.
I'm trying to get there. I need to close the work session in order to have an executive session.
All right, then I'd be.
And I
happy to
agree,
make
it's
that
been rather
motion.
repetitive, so I think we're ready to rock and roll.
Yes, thank you.
Do you have a question to the chair or a question? Because okay. So let me just do this. Thank you, Professor Scheer, for your.
Could I correct one statement that was made earlier? It's a minor point, but it's important to me. Take me 10 seconds.
I'll give you 15 seconds.
Thank you for your graciousness. It was said earlier that the death of Chief Maloney in Greenland was a domestic violence case. It was not. It was a drug raid that went bad. And that's what it was about.
Thank you. At this time, we will now close the work session on. It can be any questions for me. It can be discussed. Representative Haggath, are you recognized for your question?
Thank you, Mr. Chair. There is an amendment that I would like for the committee to review or see. I did send it to everyone because I think it's important to this session as well that we're in.
What amendment is that?
It's Harriet Gathright.
Does it
2022 1510H.
And does that involve a magistrate system?
Yes, it does.
Okay. I've already explained my position on that. I wouldn't recognize anyone to even offer an amendment on a magistrate system in respect to 294. I think I'm not going to repeat that. So at this time, we will now close the work session on Senate Bill 294. At this time, we will now open the executive session on Senate Bill 294. Before I recognize anyone for a motion or an amendment, do have one question of the committee. There is another one it's numbered 1509. It's virtually identical to what 1486 is. The only difference is if you go to page 4, lines 21 through 36 onto the next page, page 5, lines 1 and 2. That's Roman numeral 8. Roman numeral 8, the policy under the existing law was addressed by House Bill 1476 and is passed the House and is currently in the Senate. What I'm asking, what the thought was the policy set forth under that particular paragraph, we let that be decided under 1476, the House bill in the Senate. So what this amendment would do, 1509, all it would do is leave the language under Roman numeral 8 identical to what the existing law is today. And I'm just asking, if there's any preference? I like the language in 1486 better, but at the same time, that is a policy that the House passed already, and perhaps we don't revisit that with this bill. Is there anyone that has any, just to show hands, is anyone against changing it, or they want to leave it the same? I'm just telling you, I'm not even gonna bother handing it out if it's irrelevant, but I can hand it out right now. It's the same. I'm just trying not to drown people in paperwork.
Could I ask a question of the chair, just to clarify what you said? And I'm looking at section 8. I just wanted to make sure I understand what you said. When we, at the appropriate time, I just want to clarify.
You may ask the question.
Okay, so as I understand it, it will leave the law, it will leave section 8 as it is described in this amendment, and all of the bold, the shalls, and the bold, which is added language, and the language that is lined through, which is deleted language, that will go back to the original state of section 8 in the law. Is that correct?
Whatever the existing law is today,
Okay, that's fine.
it will not be impacted by amendment number 1509. That was addressed by HB 1476. So
Thank you. Are we passing it around?
Well, no, there's been no amendment introduced. I'm just asking. There was some thought of that single policy being discussed. So I'm just asking if there's a preference of the committee.
No, I'll put a different one.
1509 would leave Roman numeral 8 the exact same as it is under existing law, which is being addressed by HB 1476. So I'm just asking if there's a preference of, it doesn't mean you have to support the bill. I'm just wondering if there's any opinion. Representative Conley.
Mr. Chairman, given the bipartisan vote and the strong vote in the House on 1476, I think we should stay in line with that bill.
Although I like the language in 1486 better, I don't agree with I don't disagree with what you're saying.
That's the one. So this is 294.
We're gonna have a motion. I'm gonna recognize someone to make a motion right now.
Know what I'm voting?
This time the chair will recognize Representative Roy to make a motion.
I would like to move amendment 09.
You're being recognized to make a motion of ought to pass.
Yes, ought to pass with amendment number.
And you wish to offer an amendment?
Yes.
And
1486. I think.
I think you mean
1509.
2022-1509H.
That's the one. Yes.
Second, Mr. Chairman.
I'm trying my best. And that's been seconded by Representative Rhodes. So Representative Roy, you wish to offer your
clarify that it's 1509? Is that correct? That's the amendment? Thank you.
It's, yes. 1509. H. And the only section that is different on that is Roman numeral 8, which is just what the existing law is today, which I assume everyone is familiar with. Representative Roy,
Yes.
does every member of the committee have a copy of the amendment? Okay. Representative Roy, do you wish to speak on your motion?
Thank you, Mr. Chairman. At the risk of saying the word, I do favor a magistrate system. Having said that, with no magistrate system before us, I would like to say that it's going to take a long time to get that in place. It's going to require extensive public hearings, a lot of work. In the meantime, there are people getting out and people are getting hurt. And I know we've been here a while, but we do have to address this. And I think that the amendment in front of us is a good vehicle to do that. So until such time as we can actually get to a better system, we have to deal with the one we have. And I think that we need to do something now. So that's where I stand on this.
Representative Rhodes.
Thank you, Mr. Chairman. So a lot of times we hear people saying that they wish that they had heard, more from a particular group of people or so forth. And I think that it is not a lack of concern that we haven't heard from a lot of victims of these crimes that we continuously talk about. It's the fact of how horrendous it is for the victims to continuously have to come and relive their nightmare, which is nothing new. And it's also very unfortunate that you can have somebody come testify in a public hearing where you're supposed to be gathering information to make very educated decisions that are going to affect the entire state, to have somebody sit and testify that is given extreme falsehoods on the reality of what an exact situation is. And, I don't think that we can less, dumb down, if you will, domestic violence in any way. And I think that society needs to take into serious account the impact that these crimes have on the victims and their families and the support system that these people have.
Representative O'Hearn, then Representative Boyd, you can go next.
I just got a question for the chair. On the amendment, didn't we have a discussion about maybe changing the effective date? Or was that instead of January to either June or July 1st?
I believe there was during the work session, there was a conversation about having an effective date of, and Representative Conlon, was it July 1st? You can get the new fiscal year. There was some discussion about that. I didn't get the sense that the effective date of this was a deal breaker. Personally, I don't think that's, I respect what the representative from Dover had to say about that. I just think putting an effective date over a year away, my own opinion too, when it comes to trying to properly fund the court staff, I think if this became law, it's a much stronger, more persuasive argument that to fill those slots, not maybe, you don't want to maybe, by waiting that long, I mean, it doesn't necessarily mean they're gonna get funded. That's the other thing. It is what it is. But I think putting over a year is not something I'm really on board with. Representative Mangiapudi? Yeah.
I don't know which question I had in mind right now, so it's kind of, I'll pass.
Representative Bourdonnais.
You told us that in Amendment 1509, you changed paragraph 8 to agree with 1476, but I read at line 25, page 4, the retained period is not more than 72 hours. My understanding was supposed to be 36 hours.
Let me clarify. Let me clarify this. So 1476 passed the House, made changes to what it on what is Roman numeral number 8, paragraph 8. What I'm saying is this is stated as the existing law. I didn't want to, I could take what is in Senate Bill, House Bill 1476, you could put it into an amendment. The issue is that policy, it hasn't passed in the other body yet. And I figured the policy that is under that, on paragraph 8, let that be decided on its own merit. Since the House already took a position on it, I didn't want to repass that. This, I also, the Senate passed a different version in what was the original draft of Senate Bill 294. I'm going to let that, I assume that if the language that body prefers, they would either A, make an amendment to what is 1476. I just figured the House took a position on that and it's not contradicted in the subsequent bill. So leaving it as the existing law, we can do that. If they both were to pass and become law, I would assume that 294 would need to be signed first, and that's how that would work. But it doesn't make any, I just left it as it is.
Mr. Chairman, I disagree with that. We know that whatever is the last bill signed is what becomes the law. So if 1476 is superseded by Senate Bill 294, what the language in 294 would be the law.
But the only changes is going to be what's in the bold writing. So if technically you don't actually, I'm not really sure it matters what order they're signed in, but to the extent that you look at this as, reasserting the existing law, all that would mean it would need to be signed second, but it's the existing law. It's not being changed. If we were to change it, then it would definitely matter which one was signed first. So considering the House took a position, this committee took a position on that, that was a very narrow position, a narrow application. So that's why we're here now.
So I will say that I'm going to oppose this amendment and oppose the bill as amended. And I also want to make a statement that current law already protects people in domestic violence situations as well as stalking. So this is not something that we as a committee are ignoring. This is something that is already protected. Thank you.
At this time, seeing no hands raised, this is whether to adopt the amendment. That's the question we have now. But Representative Burt,
This is just on the amendment?
this is what right now we're just trying to. The question is whether to adopt Amendment 1509H.
Or I'll wait for the full bill.
Representative Newman.
Make sure I have that. 1509H is the latest one. I want to make sure. So 1509H, I am going to vote for. I think that it's an improvement to what's in the current one. So I will vote for that amendment, and I'll hold my judgment on the law itself, on the bill itself. Thank you.
This time, we will now move the question. If you are in support of adopting amendment number 2022-1509H, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt,
No.
Representative Rhodes,
Yes.
Representative Green, Representative Tester,
No.
clerk votes yes. Representative Janagian,
Yes.
Representative Pratt,
No.
Representative Marston,
Yes.
Representative Harriet Gathright,
No.
Representative Mangiapudi,
No.
Representative O'Hearn,
Yes.
Representative Bourdonnais,
No.
Representative Schultz,
No.
Representative Ray Newman,
Yes.
Representative Van,
Yes.
Representative Conley,
Yes.
Representative Bradley,
No.
Representative Espitia,
No.
Chairman Abbas.
The chair votes yes.
11 yeas, 9 nays. The amendment is adopted.
The committee will be in recess for 10 minutes. And we're gonna have a caucus. You're welcome to attend, Representative Burt. It's never on purpose. We will now reopen the executive session on Senate Bill 294. Representative Roy, you're recognized.
I would like to make a motion of ought to pass an amendment on
As amended.
SB 294 with Amendment 1509.
And there's a second to that? Okay. So now the amendment's already been adopted, but now it's ought to, the motion's now ought to pass as amended. Representative Newman, do you wish to speak on the motion of ought to pass as amended? Or is it a parliamentary inquiry?
A parliamentary inquiry.
Parliamentary inquiry.
Is it appropriate motion to, I'd like to make a motion to reconsider the amendment, I don't know. 1509.
There's already a motion on the floor.
Well, it's a parliamentary inquiry, so and that was a legitimate parliamentary inquiry. You would need to be recognized for a motion to reconsider. I at this time, I'm not inclined to recognize anyone for a motion to reconsider. We haven't even discussed the question right now. It's ought to pass as amended.
Thank you.
Representative Borden, do you wish to speak on the motion of ought to pass as amended?
Yes, Chair. I'm going to oppose this motion. I think that current law already takes care of all we need to do today. And to be truthful with you, we have just heard from the court system that changes that we have proposed for HB 1476 are going to have some financial consequences, as well as hearing times and court time. And I think before we go about trying to add additional workload for the court system, we should see what those ramifications are. So I will oppose the motion.
Representative Burt?
Thank you, Mr. Chairman. I'm opposed to this because there's a better alternative. Now, on House Bill 1476, I was a co-sponsor. I voted against it because it was not what I thought the bill was going to be. And now we're talking 294. So we already passed something similar to this. So now we're on 294. And I keep bringing it up. And the AG guy today said, these people can be put in jail. They do not have to release them. So this is not needed. We can fix it with another way. You know, we're sent here to Concord to do the right thing. And in my eyes, the right thing is to fix this problem. So again, I voted against 1476, the Ross Berry bill. It's in the Senate. They can pass it, and we got pretty close to what we have here. So what I'm looking at is today we could be the heroes by gutting this bill and putting in the magistrate system. Because that is really the right way to go. Yes, it's, you know, January of 24 when it would be up and running. But I think we'll survive if we did that, because bottom line, I keep coming back to it. These criminals that keep committing crimes can stay in jail. They don't have to let them out. Now, where that ball is being dropped, I don't know. I'm hearing a lot of different rumors. Everybody's blaming everybody. I'm just saying that, you know, please don't vote for this. This is not the way we should be going. There was other amendments that were not allowed to be, they were discussed during the 3+ hour subcommittee that we had, or work session, but, you know, they're not talked here. And I think we should be able to talk. Because, you know, this is important. You know, we could make a huge difference today. Huge.
And Representative Burt, if you just may suspend for a moment.
Yep.
And this is a point of order that's been raised several times in this committee. We only can discuss right now, the question that is open, all right, which is ought to pass as amended. And that amendment was 1509H. And the committee, we only can make a recommendation and adopt one amendment. It's not like when we're in the House session where you can have multiple floor amendments. That is not something we can do. So although several of them were discussed, we can just procedurally speaking in the committee, we cannot consider them all, pass one, then pass another. That's not something we can do. So just explaining that before someone raised the point of order.
All right, thank you. Well, then let's go to page 2 of the amendment. Line 6. I cannot imagine a person that does child sexual abuse images under RSA 649 would be released from jail. I can't imagine that they're going to release him from jail or her. And if you look down at the list, trafficking a person, I can't imagine us releasing somebody from jail doing that. The people that are being released from jail, not strictly Manchester, but that's where, I live close to Manchester, so I hear about it all the time. They're being, it's the, the people that are stealing from a store. Is it wrong? Yes. But that's true. It's not even on this list. So the people that are in here, we're not going to let out of jail anyways. So bottom line, we shouldn't pass this. We already passed one in, House Bill 1476. So I'm going to, and I was opposed to that. So I'm still a no vote, and I hope I can get some of you to join me and say no to this because we have a better alternative that if we stuck together, we could pass it and make it work. Thank you.
Representative Burr, if I can inquire with a question. When you say let them out of jail, are you referencing pretrial detention or being released? What do you mean by that?
Well, what's happening is they're being arrested and then they're being released, and then within a couple hours. That's from what I am understanding. And anybody on these lists, in the amendment, I cannot imagine that we're releasing them. I'd like to see somebody come in here and say, yeah, I was just arrested for child porn and they let me out within an hour. I'm guessing they're not going to be here if we ask them to show up because I'm thinking that they're still going to be in jail. So in my eyes, this bill's not needed.
Representative Byrd, I'm just trying to clarify what would happen if you are charged with an offense on this list. You still actually may be released. Understand that person may not actually be held in pretrial detention. Procedurally, the only thing that will happen is, as opposed to being in front of a bail commissioner, they are being brought to a judge. Is where your bail hearing would be, not with the bail commissioner. That's what this paragraph on page 2, lines 1 through 20 does. If at that hearing, the state could ask, and they would have to demonstrate by clear and convincing evidence that person poses a danger to themselves or to the public. In that case, the person can be held in pretrial detention. For many offenses, that can be done already as well. This is simply just saying if you commit one of these offenses, you will not go in front of a bail. That's all it's saying. So that doesn't mean the person's going to be held for an extended period of time. We're talking the time period that, as stated here, it's up to 24 to 36 hours, which is consistent with the court rules. The weekends and holidays are what they are. They're brought in front of a judge. That's what it would do. Now, whether you like that policy or not is another story, but to say that all these individuals are going to be held in pretrial detention, that's not necessarily what this would do, at least with that list.
Well, may I follow up with a clarification?
Yes.
All
Yes.
right. If you look on lines page 2, lines 2, second degree assault, that's a pretty harsh crime. The other one is aggravated felonious sexual assault. That's a pretty harsh crime. I'm assuming they're going to be held for a couple days if it's the weekend. Let's say they did this on Friday night. They're going to be held until Monday to see a judge, Monday or Tuesday, depending on what day it is. Now, if you steal a candy bar, that's wrong. But chances are you're not going to stay until Monday to see a judge. And it's not even in this bill. That's correct. But the items that we're talking here, they're not going to let you out. You know, you're going to be in handcuffs and you're going to go to jail and you're going to stay there until you see a judge. And then they're going to say, does this person get bail or does this person not? And then they're going to state the bail, you know, $1,000 cash bail or 200,000, cash bail. You know, that's what's in my, eyes on this bill is, it's not needed. It's just, we're trying to fix something that is not, that there's other alternatives to fixing the major problem here. And if we stick together, we can do it.
Representative Harry Gathright, then Representative Newman.
Thank you, Mr. Chair. First of all, I just want to say ditto to the representative from Goffstown. I think he was from the Department of Justice, the one that gave you the information about putting in an exception for RSA 597:1C. And he also told you, because one of his comment was, there's no bail anyway. So basically he was trying to get you to clean this up, I guess, a little bit, because these are things that are in place today in New Hampshire that you don't get bailed for.
It does say, except as provided in RSA 597:1-C.
Right.
So it does address that concern by the DOJ.
Okay. And the other thing was that for homicide, there's no bail anyway. I mean, so I guess we have a bunch of RSAs here that already apply. So the essence of it, if it's already law, it's already there, why do we have it?
Is that a question?
That's a question, yeah.
Well, what you're doing is that you're basically listing these violent offenses against a person or a crime against a specific person. So you put homicide under there. If you have a separate section, which is 597:1-C, that's excluding that from this policy, but you put homicide in it, which is much broader. It doesn't. Homicide can be. There's different types of homicides without naming every one. So you're kind of incorporating them all under there.
But there's no bail.
For some of them, there could be. Is my understanding. If I'm not wrong with that, someone can please correct me. Not every type. That's.
But just to make my comment and be clear, I am totally against the bill. I think it's not necessary. I think that we have the laws in place today. I truly believe that there is something that can come down the line that might help with that upfront situation of the blame that is usually put on a certain group of people. However, not just commissioners make mistakes, but judges tend to, they're human as well. So sometimes it could be either way.
Representative Newman.
Thank you, Mr. Chair. I heard Representative Burt say they shall be held in jail, and I thought I heard that no, they may be released. And I'm confused because when I look at line 8, let's start with line 7.
Which page number?
On page 2, line 7, and it's the amendment that we passed. It says, if you're charged, it starts at the top, it says if you're charged with those crimes, and on line 7, it says, shall not be brought before a bail commissioner and shall, upon arrest, be detained pending arraignment before the court. So those words to me mean that if you're arrested in non-court hours, you're not going to see a judge and you will be detained. So I just thought that might help out with my colleague John Bird's argument.
I think the confusion was, and the representative from Goffstown can correct me, was being held up, detained awaiting trial, where this policy would hold you and you're detained awaiting your arraignment, which is the first, after you're arrested, the bail hearing would be during the arraignment. It's literally the first procedural step taken in the case. So there's a difference between one saying they're going to be held awaiting trial as opposed to just the arraignment. So we're talking the arraignment has to be held within 24 to 36 hours, obviously excluding the weekends and holidays. Because that's the longest you would actually be held. Now if they find you a threat to public safety or a threat to yourself, but that's something that the state would have to ask for and meet the burden of proof. And do you understand that that's the difference?
No, I don't understand, because I look at this when I go back here and to line 28 on page 1, and it says, when considering whether to release or detain a person, the court, if applicable, the bail commissioner shall consider the following issues: safety or the safety of the public or the defendant. And then I assume that this item number 1 refers to what they're considering. And so they get to consider all of that, but included in section 1 is that they shall be held. Now, I don't want to speak for my colleague, but I was thinking that he was saying that when they get arrested, they shall be detained. You shall be detained. And you're telling me, well, it's not so bad because they'll be detained until the arraignment, but that's only 36 hours. It's half of what it used to be. I understand that. That's how I understand it. I may be incorrect. Thank you.
Well, you keep saying shall be detained, and it's a little bit. I'm just going to explain. All right. Shall not be brought before a bail commissioner.
Got that.
And shall, upon arrest, be detained pending arraignment before the court. So the detention period under that section is just to bring that person before the court for an arraignment. That is it. That's the only part that's been established at that point in time, how long that person will be held. Anything, whether they're going to be held in pretrial detention after the arraignment, that is what's at the second part of that section. The state would have to meet a separate burden. And that's assuming the state is requesting that person to be held. It does not always happen.
Where does the second part begin? I don't see the second part.
Well, and I said be detained pending arraignment before the court. The next part, arraignment shall occur no later than 24 hours after the arrest. That is on line 9 on page 2.
And where is the person who has been arrested for that 24 hours? He's in the jail. He's in the cell. Yeah.
It almost seems to me like there's some confusion of the arrest and arraignment and pre-trial process. Does everybody on the committee understand that process? I mean, we ought to. We've been on the committee for quite some time. Sorry.
Representative Conley.
Mr. Chairman, committee, I think everyone here knows generally how I feel about this bill. In particular, the first section. Yet we just went through a vote that really kind of tipped what the vote on the House floor is going to be like. I don't know how that vote is going to go, but my objective would be to get something through the House. Right now, I'm not sure that this version is going to get through the House. Around this time last year, when SB 92 came before the committee, I asked the committee and I asked the chair to hold on to it. The outcome wasn't what I would have liked, but I might suggest to the chair and to supporters of this bill to hold off on this for today and maybe try again with an amendment that is more likely to pass the House. That's unsolicited advice, But at this point, I don't know what's going to happen, but it's a 50-50 at best. And I would hate to lose the good in this bill, and there is a lot of good, and all the work that's gone into it on a tabling motion or who knows what. So I guess I'm wondering if something maybe could come forward in a week's time to find something that was more likely to pass.
And what would that look like in your?
Well, I've offered something that is, and I'm not saying the amendment is great and perfect and wonderful because I made it. It's a simpler bill. Many of the things that opponents have latched onto are not in it. It deals with the dangerousness, the dangerous people, the dangerous crimes. And I think that alone is a win. And I don't want to see the good stuff in this bill die. And I'm thinking that more work could be done. And furthermore, out of deference to my ranking member, I would love to hear more about her amendment. I know she's put a lot of work into it, and I think that the committee has expressed interest in hearing it.
So in respect to the magistrate, what I'm inclined to do, and I said this before, is have a separate ad hoc hearing. If it's a non-germane amendment, we have other bills that we could consider adding that onto. I think what we want to do is but keep going down the road of that, adding that procedure onto this procedure. I mean, you yourself just said people have a difficult time understanding the procedure, which is, to be honest, that's my biggest concern with adding the magistrate idea to this, is making sure the procedure is understood. And even on my own end, this is a court procedure, is not easy to follow, legal experience or not. So it's something that I'm just saying, I think it would muddy the waters, but I want to do the ad hoc hearing so we can kind of go through it as a committee. But are we going to be able to do that on this bill? I mean, again, the policies here, I think, and correct me if I'm wrong, you were referencing perhaps just having a section of the bill, an amendment that would only have essentially be lines 1 through 20 on page 2. It may have some of the beginning procedural sections on the first page as well. But if we just had that and didn't deal with the other sections in our debates, I mean, and I mean no disrespect to any members of the committee, we're still debating the interpretation of that. And so when I say making it simpler, I'm struggling to understand some of these other provisions. What the amendment we previously passed would have addressed if someone continues to miss court hearings, would there be a consequence for that? We took that out. We left it. We're leaving that as existing law. And I'm referencing the amendment that was passed in respect to 290, in respect to Senate Bill 92. So I'm not sure what other confusion there is.
Mr. Chairman, I don't by any means think that it's confusion. I think that people don't support the policy outlined. I think that, well, we just saw that there was a narrow vote that supported the policy of the amendment. This has been a 2-year effort across 2 chambers. And I would hate to see that work come to nothing. And I just think that the vote we just had portends a rocky path ahead. And I'm wondering if more could be done to get to a point where we're more likely to pass it.
I think once we have a finished product, we'll get a better idea of that. The problem is that even this amendment is a pretty drastic change. I don't know if drastic is the right word, but there's some significant changes to 92. So, Representative, has any members who haven't spoken already that wish to speak? Any questions about any other sections of the bill? Any misunderstandings? Any comments? This time, Representative Bornay.
Thank you, Mr. Chair. I, like most of the people except for you, have really little experience with the criminal justice system. Terry as well. And I think a lot of these ideas, I'm sorry.
By Representative O'Hearn.
O'Hearn also, but that is a minority of the committee. And I'm wondering if we need a really sort of a mock procedure where we arrest people, detain them, have bail hearings, and up to court appearances as just a way to make us understand the process. Because right now, all we know is what we hear abstractly or we see on TV, because most of us do not appear in criminal court. We don't know what goes there. All we hear is rumors. But that is just a suggestion for something to do in the future. I mean, maybe we could even get a member of a professor to lead us through such a thing. Anyway, that's just sort of a idea.
I don't think it's a bad idea to have some type of flow chart, perhaps put together by, I'm sure someone may help me do that. But I think that part of the issue, and again, that goes back to my concern about respect to Representative Harry Gathwright's amendment is, I'm not allowed to mention it, but it's the complexities of it. So that's my, again, point taken. Representative Schultz.
Well, on that note, thank you, Mr. Chair. You know, I am still not really a member of this committee, but I really appreciate participating. So I do want to add that as a caveat. But I keep trying to find a list of New Hampshire bail commissioners on multiple websites run by that. You can't find it. My point is just that for so many reasons, the existing law, for whatever purpose, should be enough. And I believe that is a known fact by more people than would admit. And I'm inclined to follow my ranking member with her vote.
I believe at the last public hearing, they don't make the names public. I just, so you don't keep looking for it. The first, they're kept private or confidential for a reason. And then I think there was less. It was mentioned during testimony last hearing we had on Friday. I don't remember the exact number. I want to say it was around between 70 and 80. But there's a lot of vacancies, and they're having trouble filling those. So, but judges are a part of their appointments public. So I mean, it's a public appointment. You know, they're appointed in the executive council. So the names of the judges are public, yes, but bail commission not. Representative Welch.
Mr. Chairman, this is really directed at Representative Bourdonnais. He should go down to the Manchester court. I think it's on a Monday morning when they hold the arraignments, see what the process is. I've been there. I took the committee there several years back. And it's horrifying, to tell you the truth. And I talked to a woman down there who was a victim of domestic assault, and I overheard the conversation that the guy stuck a gun right in her face. Well, I guess he got locked up. Good enough for him. But you ought to go down and see how it works, rather than listen to somebody tell you how it works. That's all.
Any members wish to speak that haven't spoken already?
Parliamentary inquiry, Mr. Chairman.
You're so recognized.
Thank you. Could you explain how practically this committee could hear an amendment on a magistrate system, and whether, in your opinion, such a bill could be acted upon this term?
So, two things. We could have an ad hoc hearing. At that point, we can discuss any issue that's within the purview of this committee. We don't need a bill. So we can discuss that. Now, if it's a non-germane amendment, we would have to notice that. So we could technically do that with any bill. It doesn't have to be one involving bail at all. We could do that. We just would need one, it would have to be ruled non-germane by the speaker, and then we have to notice the hearing separate. We can do that on any bill at any, I don't say any time, but that's the process we can do it. We have other bills in the committee. There'll also be some second committee bills we can do.
If I may follow up, is it your belief then that we would have an avenue to pursue that if the committee were so inclined? There are bills, and there are bills that could be tacked onto.
It can be literally any bill it can be tacked onto as a non-germane amendment. So yes, we have other bills that my understanding would be coming to this committee.
Okay.
I'm not clear if there's any second committee bills. I haven't looked at every single Senate bill, but there are other policies. So, other bills that we can do a non-germane amendment on. And I'm willing to at least consider doing that. And
Okay, lastly, sorry everyone to belabor this. So does that mean, are we saving a bill from today, or are we going to exec, or to make sure that we have something along those lines?
that's a good point. All of the early deadline bills, we finished the exec on all those on Friday. So could we meet again? Yes. I think we could exec everything, maybe as long as the bill is in the committee, even if we exec it, we could still hold on to the bill and then move for reconsideration at a later time. I guess my concern is that the procedure is what we're going to be more discussing. I think it's very clear. We all like a system involving magistrates at some point. I just think we got to figure out the procedure that those magistrates will follow. And that's where the real debate's going to happen. So I'll be honest, I know a lot of people don't like these. Study committee or a commission would probably be the way to go, discussing the different policies, but we can do that in an ad hoc hearing, which would accomplish that goal. And I'm sure our friends from the court will show up at that ad hoc hearing. And at that point, we would have a better idea on how to do this and what direction to go. That's just my opinion, because that is a major change in the law. It's not as simple as just a light switch going from one to the other. And I don't know how long the hiring process would take. There's a lot that goes into that. Representative Mangiapudi.
Thank you, Mr. Chair. Sorry to belabor, but if you're saying, if I understand you correctly, the amendment that Representative Harriet Gathright has brought in, that can be non-germane, can be attached to any bill. If it is any bill, why not attach to the bill that we have on hand that is related? That's all my question.
So you're asking in my opinion? Well, number one, we would have to merge that into the current amendment, number one. Number two, there's the difficult debate that we're having on policy and procedure that said magistrates will have to follow, which, as you can tell, we don't all agree on. So I think we need to have that discussion separate. That's my opinion. When I say it can be a non-germane amendment, can be brought up on any amendment, that's by non-germane, it means it's not relevant to the original bill. So it can be done. So my concern is, again, the procedure. Let's separate those two policy decisions and debate it that way. That's my opinion. Do any members wish to speak that have not spoken already? He's already spoke. Representative Welch, did he speak? Did you speak already?
My suggestion is that if we were to entertain a non-germane amendment and merge it with a current bill, you could have two effective dates. Section 1 effective whenever this one is, and the Section 2, which would probably be the magistrate bill, would be effective the year later.
I understand that can be done, but the policy that's inside the amendment right now, 1509, still needs to make it out in order to be considered. So again, putting them together, you may lose the magistrate because of the policy decision, or some people may not want the magistrate. We haven't heard that. We haven't really floated that beyond this room today. And I know I've talked to some other reps about it, and we're kind of gearing up for that. But I think if we rush that out right now, yeah, I point well taken. At this time, we'll now.
Plenty of people spoke like 4 times. I've spoke once.
I'm recognizing you to speak. I just,
all right.
You know, you're up.
Thank you. To my friend in front of me, yes. Any dream that this is going to happen is a dream. And, you know, that possibly we could attach something on. Because let me explain. We have house next Thursday. We also have house on Thursday the 5th with keep Wednesday open, because that's when everything has to be done. So there's 0 chance that we're going to do anything in the next 2 weeks to get this out, because after the 5th, if I don't have the calendar in front of me, but if I remember reading it right, that's the end. We're done. And then we have house on the 12th and the 26th, and we're done for the year until next election. So, you know, so if you're voting yes on this, just to have a hope, I'm going to dash your hope. Sorry. But you're a friend, and I think you deserve the truth. Thank you.
Representative Berg, we're always available to meet on Fridays as well, just in case you kept up with the schedule when the committee regularly meets, which are Wednesdays and Fridays.
That is correct.
So that is something that we can make arrangements for if we so wish. And we have other bills. And then there's also some potential for second committee bills that can be assigned to the committee. We would have those as well.
Yes, and the chair can waive those off, which he has in the past.
I could. At this time, we'll now move the question. If you in support of the motion of ought to pass as amended, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burritt.
No.
Representative Rhodes.
Yes.
Representative Green. Clerk votes yes. Representative Testament. Representative Janagian.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Managiaputi.
No.
Representative Ahern.
No.
Representative Bourdonnais.
No.
Representative Schultz.
No.
Representative Ray Newman.
No.
Representative Van.
No.
Representative Conley.
No.
Representative Bradley.
No.
Representative Espitia.
No.
Chairman Abbas.
Chair votes yes.
9 yeas, 11 nays. Motion fails.
So Representative Conley, what's your desire to do here now? Would you like to be recognized to make a motion?
I'm not sure what that motion would be right now. Truly.
Well, the ought to pass as amended didn't work. So there's the options interim study, which I wouldn't recognize someone for that because this committee studied it long enough. Would you like to make a motion of you either can do a reconsideration or an expedient to legislate?
Mr. Chairman, I'd move to reconsider amendment 1509.
Well, it's the ought to pass as amendment. The ought to pass as amended is what would need to be reconsidered.
Could the amendment not be reconsidered now with the floor open?
We would. That's parliamentary inquiry.
So, Mr. Chairman, I said exactly my feelings on the bill when I spoke a few minutes ago. Let's get something that can pass. And I don't think this can pass. I don't think it will pass. So, my suggestion would be to think on it for a little bit, even if it's a couple days, and try to get there. But I would not be supporting an ITL at this time.
So what, well, let me ask you this. We have several other amendments here. If you want to reconsider what we've adopted, which ones are we working with here?
Mr. Chairman, I'd move amendment 1530H.
Well, that's the amendment that we would have to reconsider, but which one's that? You mind? You want to just so you just want to consider the violent crimes section, we'll call it.
Mr. Chairman, I think that would have an easier time passing. We have 1476, which deals with repeat offenders while on bail. We heard on the House floor the prime opponent of HB 1476 specifically saying that these provisions in SB 294 were a reason to vote for the bill. And I don't want the baby thrown out with the bathwater.
But that's again, I don't actually have a copy of your amendment. But let me ask you one question. If we did that, what is the objection you believe that's going to happen with the other sections of? I mean, I understand this is simpler because it only addresses one section of the bill.
So there's something that we all understand about somebody accused of a violent crime. They are not, we just heard testimony from the Attorney General's office that more often than not, people under this whole basket of crimes in our state, including those here other than homicide, including child pornography, including second-degree assault, are let out more often than not. This addresses that basic point without the other points that could that opponents have raised, the litany of issues opponents have raised time and again are gone. So we focus on the violent crimes, we go ahead with 1476, and we have a pretty significant change to our bail statute that addresses probably 90% of what everybody who supports the reform wants to get. And I believe it would pass.
I don't remember anybody testifying.
Forgive me if I misspoke.
Parliamentary inquiry.
So when you list these offenses under what is 1503, that amendment, I'm just asking you, what's the difference between that and the policy we have under 1509?
I think the second section of 1509 is the primary. I'm not speaking for anyone. I know that there are people in this room who won't support this on principle. But this is simple, and it doesn't have the secondary effects of all that is contained in 294 beyond this point. This is something, if you ask any person on the street, I think 9 out of 10 would agree that these people should go before a judge. Keep it simple, keep it to that, and I think it's a successful bill.
Parliamentary inquiry, Mr. Chair.
You're so recognized.
I just have a curiosity about the process. We're talking about an amendment and whatever's going to happen if in fact that motion is made. Will we have a discussion about that?
Yes.
Thank you.
I guess where I disagree with the representative from Dover is that when I asked any members of the committee what are their objections to the other sections of the bill beyond, which was lines 1 through 20 on page 2, I did not hear any objections to that. I did not hear complaints about that from any member. So I understand we're worried about, I'm not clear that the people who support the policy, I'm not sure we're changing many votes with that. That doesn't seem to be where the debate is. The debate is the bail commissioner. And I'll be honest, some of the language in there is really clarifying the existing language. I mean, the debate has been lines 1 through 20 on page 2 of HB 1509. That's where we've been dealing with this the most.
Today, that's where we focused on, but a lot of the past discussion on this that is sort of baked into this is the back half of the bill. And this has been the focus today, but the opponents that I've heard from are less concerned, far less concerned about this stuff and far more concerned about the second half of the bill.
You're correct. They took exception with the language rebuttable presumption, which is under existing law, the language that is in the bill. So the rebuttable presumption language was not something I came up with as a point of being creative. They're saying that that's unconstitutional. Well, I don't agree with that, but to the extent that even if they're correct, that rebuttable presumption language is in the law already. So it's not shifting the burden. Now, the two other sections that dealt with that, one of them was the section on whether a person continues to miss court hearings by the third time or the second time in the same case, would that person be held and have to overcome the rebuttable presumption? Well, that language in this amendment is this existing law. The only other, this is just objections I've heard from non-elected members, and I've heard this from even some elected members. The issue is if you get arrested 3 times, so you're out on bail, you get arrested again, and now we're talking a Class A misdemeanor, drunk driving, or a felony. You get let out, you're now on bail, been arrested twice, and out on bail on both of those. You get arrested now a third time for Class A misdemeanor, drunk driving, or a felony. At that point in that bill, in that section, again, the existing law says rebuttable presumption, but this clarifies that language because my understanding that that's been interpreted differently. So we have that. So that's the other objection to it. And I understand people oppose that, but I'm just explaining the rationale that's being presented has to do with the terms rebuttable presumption, which the existing law has that. So I guess defeat the bill, congratulations, but that problem will exist whether this passes or not. Yes. We recognize for your point of order. There was 2.
Thank you. Is there a motion on the floor that has been seconded?
No, we're just having a discussion. We're debating. I was trying to encourage my friend from Dover to make a motion of inexpedient to legislate or reconsideration. And he's.
May I be recognized for making a motion?
I'm going to leave it to Representative Conley to make a motion. If he's free to pass if he doesn't want to make one.
Do I have a choice in motion I would make?
Yeah, I can't make you do anything. It's a free country.
Mr. Chairman, I would move Amendment 1503, and then I would ask, given that we've had a lengthy back and forth, to move the question fairly quickly. And if that fails, I still would not support ITL. I would support a pause to try and fix a bill that will pass. But let's cross that bridge when we get there.
Well, let me just, can I see a show of hands on 1503? How many members of this committee would support that policy passing? Just, okay. The problem is, I didn't see the majority of hands raised. If someone want to do a recount? If you would support and not to pass as amended, and it's now 1503, you get what I'm saying? That would need to pass the committee too. And I will put my hand up because I don't think having 1503 is better than having nothing. But let me ask, who would support that? I'm just. Kevin. Perhaps a floor amendment would be the way to go if that's the case, because we would need a positive motion. I'm just explaining, we don't. I don't think the point that's raised by my friend from Dover is a bad point, but we would need to, before we do all these reconsider all this stuff, we need to actually pass it in the committee. I just did to save us time. Raise your hand. No, we don't have the votes to do that either. So.
Question.
Point of order, Mr. Chair. Is Representative Conley the only person who can make a motion at this point, or can anyone else make a motion?
He's not obligated to make a motion. I'm just asking if he wants to. No, I'm just. Well, we would have to reconsider the. We would have to get rid of the actual amendment. My understanding, right? We would have to, because we already passed the amendment. So we would have to reconsider that. But what I'm getting at is we can reconsider the adoption of 1509. I'm trying to get a feel whether 1503 would actually pass, and the answer, from what I understand, is it's short on votes. So that going down that road, I don't think is going to get us anywhere. So I guess now what's our other option here?
Can I make a motion?
I guess let's consider another motion, but I'm making clear now that I will not be supporting ITL.
If you reconsidered the ought to pass as amended, would you be inclined to vote a different way? You and I discussed this in detail. We worked together.
We have discussed this at length. I don't know if we can't even agree on section 1 as a committee. I think that suggests where this bill is headed. We don't have a deadline that says we have to do this today. I guess I'm saying I'm not ready to concede defeat on this. So is there could we pause this for a week? Could we pause this till Friday?
We would have to notice it, so it's not noticed for.
The deadline's 3 o'clock for the calendar.
Oh. We would have to reconsider it. So,
Mr. Chairman, I would move to reconsider Amendment 1509.
So we're reconsidering 1509, and are you?
I think I misspoke, Mr. Chairman.
Representative Haddock-Gathright?
Okay. My understanding is that ought to pass as amended failed.
Correct.
So how can you go back and pull that amendment?
We would have to reconsider that. Then we would have to reconsider we have to go with a different amendment. We would have to reconsider that as well, adopting that. So my question to everyone is if we did all that, would that other amendment actually pass in the committee? And the feeling I get is it will not, based on the hands raised. So I'm kind of lost where to go other than inexpedient to legislate at this point, or interim study. So
Can we get to a point we can just pass a clean bill, no amendments? I mean, what are the sense of the committee? Just pass 294 as is, and deal with floor amendments.
that's an option too.
Could we send it?
Needs an amendment anyhow. It's got a wrong reference of the RSA in there, if you recall.
What's the wrong reference?
Well,
You're talking about the original bill.
The original bill.
Yes.
On line 25, page 1, it references RSA 630:1, and it should be 630.
Line 26.
Hang on a minute. No.
That was identified by the.
Yeah.
Yes.
So-
Line 26. Oh, line 25, I'm sorry.
630 should be 631.
No, 630:1 should
So
be
re-
630.
I'm going to give my friend from
Line
Dover a hint. If
25.
we don't reconsider the ought to pass this amendment, I'm going to be inclined to recognize my friend from Keene to make a motion, which motion of inexpedient to legislate.
Mr. Chairman, we had a motion and we had a second. We had a straw vote. I don't want it to go to interim study or
I agree. No interims. So what I'm going to say is it's ought to pass this amendment. It failed.
you want to get into the board.
I think if people want to vote and they don't want to hold criminals who commit violent crimes against people and child pornography and
Point of order,
let them
Mr.
do it.
Chairman.
Point of order, Mr.
Let them do
Chair.
it. That's what it does.
Yeah, Mr.
All right.
But you're making motive
I'll
here.
gavel-
What the
gavel
hell?
myself. I'll gavel myself. I apologize.
Oh.
Am I allowed to gavel myself?
You know, you know,
It's already. I apologize already, but I'm just saying I'm inclined to let. That's what it is. We don't have we're not going to pass it. We'll go that route.
Mr. Chairman, there was a motion made in a second. We have not discussed the amendment, specifically what the amendment would do. I would like a vote on the amendment.
Your amendment.
Yes.
Okay. So in procedure, my understanding is we have to now still reconsider the ought to pass as amended, right?
No.
Don't we have to get rid of the First Amendment? It was the amendment was adopted. We have to now.
Mr. Chairman, I text the clerk. He says we have to reconsider.
That's what I'm trying to say. I'm trying to get someone to make a motion to reconsider the ought to pass as amended. Yes. People want to reconsider another. If they won't do that, then it's an ITL.
Mr. Chairman, I would move reconsideration on ought to pass on SB 294 and move an amendment when appropriate.
So ought to pass as amended. That's what it is. Is there a second?
Second.
That's been seconded by Representative Roy.
And I would move amendment 1503, and if I may speak to it briefly.
No, we don't do it at this time.
You can't do it.
So we have to reconsider the ought to pass as amended.
This is New Hampshire.
All right, I'm going to explain. The ought to pass as amended, right? We need to reconsider.
Who's the second?
So we have to reconsider the adoption of Amendment 1509. That needs to not be what we do. Okay? So it's the whether to adopt Amendment 1509. All right? So that's my understanding what we have to do next. All right? So we're going to reconsider that. And you need to
I'm confused now.
Yes, once it's reconsidered, then it's whether to adopt it. At that point, I would just pray that Representative Roy withdraws his motion to introduce said amendment, and then I'll recognize the representative from Dover. So the motion is to reconsider adopting Amendment 1509, and is that second? That's the motion you have to make.
Ought to pass as amended is the motion.
That motion failed.
No.
To reconsider that motion,
Just reconsider the amendment.
right?
We're reconsidering the amendment.
So moved.
You can't
If someone thinks we're not following the rules, it's a point of order. But in order we cannot consider my friend from Dover's amendment. We cannot do it unless we reconsider the adoption of 1509, that amendment. I don't know how many more times I can say that without explaining it any other way. It needs to be, we got to reconsider that. All right? That is what we have to do, because we only can adopt one amendment. And I've said that, I want to say 10 times. So I'm trying to get us to that point, but no one wants to do that either. So bear with me here. You have a, I'm not going to recognize anyone for any questions. Right now, I'm Representative Conley. You wish to do a reconsideration of 1509.
So moved.
Is there a second?
Second.
A second by Representative Welch. Representative Burt, you have your hand raised. Do you wish to discuss the question?
Yes, I think you need to talk to the clerk because my understanding is we have to reconsider ought to pass as amended. It has nothing to do with who the amendment is or what the amendment is or anything. We have to get rid of the ought to pass as amended and then move forward. So once we do that, then he can bring any amendments in.
Are you suggesting the ought to pass as amended failed?
But we have to reconsider it, and then it's a blank, then there's nothing. Then it's all done. You know, it's like we never voted. Then we say, okay, now what do we want to do? Then we move forward with an ought to pass amendment with this, with Representative Conley's
I'm going to
amendment.
go into, I'm going to go into recess. I'm not sure what question you've presented to the clerk.
I can write, I'll tell you, I got it right here.
Can I go to the ladies' room while he's coming over?
I wrote in criminal
right.
justice, okay, do
So
you want me
listen,
to tell you?
Listen, what we're going to do, if someone does not believe I'm following the rules properly, they can raise a point of order. That's what they're for.
All right, point of
Right.
order.
Please state your point of order.
All right, the point of order is I'm reading from the clerk that the only option here is reconsider of the ought to pass as amended. Then it gives us a clean slate.
right.
The bill has done nothing.
I'm going to go into, the Criminal Justice Committee will be in recess for,
I think what Bert's saying is that eliminates the amendment.
Correct. It eliminates everything.
would it? Okay, that would eliminate the amendment as well.
Correct. That is the proper motion.
So we want to reconsider the ought to pass as amended. All right, but I'm going to go into recess for 5 minutes. I want to speak to the clerk, make sure we're doing it properly.
Thank you.
I know, if we have 1476. And he can go, if he wants to put it in 1476, do that. You have something you want to put in 1476 that's not there?
Okay, I don't think they will. I think we're counting on you.
There's nothing this right.
What? Oh, are you looking for me? Sorry.
Right there. Ross Berry or Reconstruction. It's essentially a killer because they want it. Because they want all of it. I'm saying, no. The line lights with the real world. That's why I'm doing it. Well, yes, that's also not that. Yeah. So I reconsider the OPPA, then you gotta reconsider about No, it's not. I don't know. I had those two considerations, and then OPPA on another.
Just what your meetings are usually like?
But there are, to me, this is the worst I've seen. So when you ask me, I've seen kerfluffles in this committee. And I think you come from Salem.
I do.
Morris wants to go to the Senate. He wants to take Morris. And I'm assuming you're in the camp that would vote for him to be in the Senate.
No one else.
That's interesting. Well, that's not necessarily true. There'd be a Democrat. There'd be a Democrat.
Oh, yeah. No, I am supporting them, but also right now, no one else is.
Right. I hear you. But just between you and me, and don't get me wrong, he don't have enough experience. And if I was in Salem, I wouldn't vote for him. So, this is his second term, and they shoveled him along because they want him to have this on the resume. So, you know what I'm hearing from other people that are chairs, not meaning disrespectful, saying he don't have the experience. He's considered one of the worst chairmen of a chairman that I know. Some of them are what it's worth. And he's been nice to me, and he's been bad at me, and blah, blah, blah. I'm just saying, I've also been in this committee when we had chairman who, excuse me, what the hell they were doing. And even up to and including David Roberts. Well, this is my third term, and so I was here on criminal justice about, prior to this term, I'm thinking it's 2 terms prior is when I was here. It was my second term in the House. My first term I was in elected law. Second term I went to criminal justice. And John Thaw was the chair of Welch, was the vice chair. And it went like clock, right? And then I didn't get elected. And I'm from Manchester. So, and I've come to my final conclusion, what I'm gonna do come this election. I'm gonna spend my 2 ups, put my name in, and see what happens. I might put up a few signs at some point. I gotta, cause I got them, right? And I might not. And if I get elected, terrific. If I don't get elected, that's terrific.
David was saying he's not.
No, I know, him and I, we talked about, we're the same age. I'll be 82 in August. And he's 82 now.
Okay.
So we kid about it. And I don't mean any.
No, I understand.
One of my things that I find that I've come to the conclusion, he's a lawyer. I find one of the things about lawyers, they want to talk too much. They want to comment on everything. I mean, David meant she went into the Senate to speak, and they only allow 15 minutes for a hearing. He just introduced the bill. The next person after him was a lawyer who spoke for 45 minutes. You see, and it's like,
They have to keep things moving along in the Senate because they've got so few of them. I don't know how they do it.
yeah. Well, one of the things that I noticed that I would do it if I was a chair at any point. I don't ever expect to be, but my point is, I would schedule a bill at 10, at 10:15, at 10:30, and so on, every 15 minutes. No, they're not gonna knock off. But the point is, when you get ready to call a bill, you're either in the room that you want to open up and testify, or you're not. So you gotta do like the rest of us. You gotta sit down, sit back, and wait your turn.
Yeah, and you're ready.
And be ready. And that's what the Senate does. That's how they do it. They do it every 30 minutes. And you know, that has some validity. Because what we end up doing in the House side, okay, well, we'll schedule it at this time and then we'll wait an hour and a half. Well, what if you're done in 15 minutes? Now we're all sitting around twiddling our thumbs.
That happens. Usually it's the other way, but that does happen too.
Exactly. And the flip side of that is these people that want to come in and testify, because you told them they weren't going to open this bill until 11, they're not going to show up. They're out having tea and crumpets.
Yep.
So I'm just saying. There's a lot to be said for both the way the House, the way New Hampshire runs bills and legislates. I look at it and say, you know what, there's something to be said about the way they do it in Washington. Now, I'm not saying I'm picking one over the other, but I love the idea that in Washington, if a chairman of a committee don't like your bill, it ain't seeing the light of day.
Right.
Whereas in New Hampshire, you put in a bill, not only does it see the light of day, it's gonna get a hearing in the full House. Up or down, doesn't matter. You know? And I mean, I get a kick. I mean, here's another thing that I get a kick out of. I really do. Think about this for a minute. A bill comes in. A bill goes to committee. A bill gets hashed out. Gets argued over, amended, finally goes to the clerk's office. I don't care how it is. Ought to pass, ITL, doesn't matter. But it also can go on a consent calendar or whatever. If it's on a consent calendar, it only takes one person, anybody, pulls it off. Okay, that's fine. Okay. We get to the bill finally being heard in the House, and some jabroke stands up and says, I want to table the bill.
All right, we will now reopen the executive session on Senate Bill 294. I believe the open question was, there was a motion to reconsider the ought to pass as amended. At this time, we will now move the question. If you in support of the motion to reconsider the ought to pass as amended, please say yay. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Vice Chairman Roy votes no.
Representative Welch.
No.
Representative Burt.
No.
Representative Rhodes.
No.
Representative Green. Clerk votes no. Representative Testament.
No.
Representative Janagian.
Yes.
Representative Pratt.
No.
Representative Marston.
No.
Representative Harriet Gathright. Reconsideration.
Motion to reconsider the motion of ought to pass as amended.
No.
Representative Mangiapudi.
No.
Representative O'Hearn.
No.
Representative Bourdonnais.
No.
Representative Schultz.
No.
Representative Newman.
No.
Representative Van.
No.
Representative Casey. Excuse me, Representative Conley.
Yes.
Representative Bradley.
No.
Representative Espitia.
No.
Chairman Abbas.
And
Can I
Represent-
change?
Yes, you may.
Yeah, I misspoke. No.
Chair votes no.
19-2. Reconsideration fails. Oh, I'm sorry. That's correct. John.
So by a vote of 19-1, the reconsideration fails. Representative Conley, do you wish to make another motion? You wish to make one of inexpedient to legislate?
Mr. Chairman, I'm not going to make that motion because I don't support that action.
Representative Bourdonnais, you're recognized to make a motion.
Make a motion to ITL.
And I'll second.
It's been seconded by Representative Burt. Representative Bourdonnais, do you wish to speak to your motion?
Yes, I do. This bill is not necessary. It makes the court system worse off than it is today, and already the court system is backlogged. Who knows how long? I did talk to court officials during the lunch break, and they don't know when, if ever, they will ever catch up. So adding more caseload to the court system is not going to help. And just so other reps in the committee know, already for domestic violent situations, current law does support being able to retain people. That's all. Thanks.
Representative Burt, you are recognized.
Thank you, Mr. Chairman. I support the ITL. Again, as I said in the past, this bill is not needed. If you read, if you read the underlying bill, the people that they want to hold, they can hold now, according to the New Hampshire AG. Thank you, and I hope you support the ITL by voting yes.
Representative Conley, you're recognized.
Mr. Chairman, thank you. So I don't even know what I guess we're voting on ITL of the amended bill, which does a lot of things.
Let me just correct it. When it's a motion of inexpedient to legislate, there's no amendment. So it's the underlying, we're back to the inexpedient to legislate is discussing the underlying bill, not any amendment at this point. And just for a point of clarification, and to my friend from Nashua, the ranking member, the amendment that you had prepared, I received word that was ruled a non-germane amendment.
So I don't want this to, so I don't know what's happening after this. I don't know what's going on. I don't want the policy to die. I'll be voting against ITL, and rather than hopefully not subject this committee to another round of motion upon motion, but I erred in my original vote. I made a mistake. I don't like that I made that mistake. And I am hoping that there's an opportunity to undo that mistake by bringing the bill back in its amended form, if that's the only form we're going to get. We were told by law enforcement something needs to be done. We were told by our by our county attorneys something needs to be done. We were told by the Attorney General's office they support the bill. These are the people who deal with people who break laws in our state. It's not, respectfully, the ACLU. It's not, respectfully, the people on Twitter. Those are the people who deal with people who commit crimes. They want this to pass. I trust their judgment, and I am kicking myself for the mistake I made, and I'm sorry that everyone had to listen to that, but that's the way I feel.
Representative Scholz, you're recognized.
Thank you, Mr. Chair. I genuinely believe we genuinely all care about making sure people who have perpetrated violence indeed should be punished. I think we all agree with that. What we really don't always understand as lawmakers, and I guess I should just say I speak only for myself, just in life in general, what I think is going to work or be helpful as an action is not always true. The things we think that might make us happy aren't always true. The things that we think are going to do a lot of things, especially as legislators, aren't always the most effective way. And I do genuinely believe all of us care about safety, and we disagree. Plain and simple, we disagree. I'm of the camp that believes strongly that bail reform was the right thing to do. It remains the right thing to do, and we just need to enforce the laws on the books. And we led the way in many ways in the nation. And so we need to work on the things we agree on and go from there. That's my suggestion. Thank you.
Representative Testman.
I too would like to see, bail reform work. What I hear from Dr. Scheer and others is that it's good. I'm not sure I really agree with him, but what I also hear is that we've got a bunch of numbskulls as bail commissioners.
Excuse me, Representative Testament. Let's not make any generalized statements like that, especially using that terminology. That's not fair. So I just ask you, see with caution.
We have a group of people, commissioners, who are obviously not well trained.
Please.
It's not their fault. Anyway, we need to fix the bail commissioners, and that's where the issue is right now. There may be a magistrate thing coming later, so what? But the whole really seems to be with the bail commissioners.
Representative O'Hearn.
Just a question for the chair, because after these long hours here, I'm getting a little confused. So this, right now, we're inexperienced to legislate on the amended because the reconsideration.
The underlying bill. Because in order to discuss an amendment, there needs to be a positive motion. We are past that point now. There was an attempt to reconsider, to perhaps get to a point where a different amendment could be offered, but we did not get to that point. So now we're talking about the underlying bill. Representative Newman.
And the underlying bill means the way it came from the Senate. Is that correct?
Yes.
Thank you.
Do any members wish to speak that haven't spoken already? I will point out, I do appreciate the effort we put into this. However, this was not a repeal of the bail reform that passed. This was a narrow focus on what I would say was some of the more egregious situations. And that's what this was intended to do. Someone who gets arrested 5 times for drunk driving in a 2-month time period is still able to be released. I think if someone were to be arrested for that many times for that offense in a short time period, there's something else going on. But the issue is, it's bail. They're being allowed to be let out on bail. That puts the public safety at risk, puts all of us, everyone at risk, and even themselves at risk. This was an opportunity to address that, where if that person was arrested for 3 times for drunk driving, at that point, there would be a rebuttable presumption that that person would not abide by the conditions of their release. And I will say, in respect to bail generally, if you have conditions of your release and you don't follow them and there's 0 consequence for violating the conditions of your release, I'm not even sure why there is a system of bail in the first place. There's absolutely no accountability, no consequence if those conditions are not followed. I'm not saying that because someone violates the conditions of their release that they should automatically be held, awaiting trial just for a violation. But if there's repeated violations of those conditions, what is the solution to have someone have some accountability and actually make an effort to comply with those? And we had a list of offenses. All these offenses were violent offenses against an individual. We didn't have crimes against property per se. Arson's not on the list. Let's just go. I'm going to go right down the list. You have the assault, felonious sexual assault, domestic violence, second-degree assault, homicide, first-degree assault, kidnapping, stalking, trafficking of a person, human trafficking. These are the offenses that was the intention to address these egregious situations. That's what we were dealing with. We also had child pornography, robbery, and anyone who contains any child pornography images. And the rationale for that is that if you are containing those images, you're supporting the industry of child pornography. That's consistent with how the Supreme Court of the United States has ruled. That's what we were trying to address. And our recommendation from this committee, I'm not going to support an expedient to legislate. But that's where we're at right now. Representative Harry Gathright.
Thank you, Mr. Chair. Again, I think we addressed in HB 1476 and HB 1476, I think we addressed the issue of releasing of defendant pending trial. And while out on bail, retaining those folks. So, but what I want to say about all the different RSAs that are listed there, today, they can be held. So to say that we don't have the laws today, in my opinion, is not true. The laws are there. People choose to either do them or not do them. So I don't think that's a setback for this committee, because I think everybody in this committee cares about public safety. But all we're saying is that today, these things are there. We've done our job by having the laws. So for me, yes, I will vote ITL on that bill, because it's not necessary. It's already part of the law today.
Right now, just the clarification, Representative Harry Gathright, it has to do with the police have the discretion to pick and choose which people they want held and don't want to offer a bail commission to, and which ones they don't. And the idea is to not leave that in the discretion of the police. And that often is a decision that's made from outside the department. That's my understanding. But in respect to 1476, that was not going to be, that has to do with someone who's arrested while out on bail. That's not whether to revoke that person's bail. That's when I'm referencing a repeat offender. That section does something different. All right. I was talking, that's under paragraph 2. That's 2. I'll make sure I got the right section for you. Anyway, paragraph 8 was 1476, and that had to do with simply holding the person to be brought before a judge for violating the conditions of their release by getting arrested again, not whether to revoke the bail. So when to say we addressed that problem of repeat offenders, it was not addressed. Representative Roy, Representative Roy?
Thank you. Like you, I can't support an ITL on this. I've heard someone say, you know, that we have the existing laws in place and let's let the system work. We've already got these laws. The problem is that they're not being held in many cases. And, you know, there's finger pointing as to who's to blame for that. But basically, at the end of the day, we're asking bail commissioners who came before us most recently and told us that, you know, 40 to 60% of the time they're not being paid. So we're putting the safety of some Granite Staters in the hand of basically volunteers and asking them to make these decisions. And it appears that, you know, in some cases it's not being made correctly. We, through this bill, would have specified where people have to be held for a judge to review. And by kicking that down the road, it just leaves the status quo. And we've heard from the chiefs of police, from citizens, it's not working the way it is. It needs to be tweaked. And I just can't support, I can't support an ITL in knowing that there are domestic violence victims and some of these people who are subject to people just being released on PR, and the decision being made, like I said, by someone who's basically a volunteer, or at the very least not very happy about their job because we're not paying them. So I won't be supporting the ITL.
Representative Bornay?
Thank you. Mr. Roy referenced that we had people testify that it wasn't working. I have a list of the people that testified on this bill, and of the 7 groups of people that testified, only one of them was for the bill, and that was some police officers. That is it. All the others were against the bill. I'm sorry. Bossy was here because he didn't testify. He just basically introduced the bill. So hearing lots of evidence about our testimony that the bail reform is not working is not quite correct, in my opinion.
Representative Spitia?
Thank you, Mr. Chair. And in response to just some of the comments, I know that, you know, if in fact that we're thinking that some of the folks who are making these decisions are, quote, volunteers, then I think we need to look at more of what's going on, you know, behind the scenes and looking at ways that we can find a better platform to try to get this, you know, try to get a lot of these folks, you know, through pre-trial and process, because obviously it's not working right now. So unfortunately, this bill doesn't address that, and you know, I'll be voting yes to the ITL.
Representative Schultz, you have a parliamentary inquiry?
Yes, I'm just curious to know how many people signed in support or opposition online and in person, that if you have that available.
I don't have that information in front of me.
That's in person.
At this time, we'll now move the question. If you're in support of the motion of being expedient to legislate, please say yes. If you are opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy,
No.
Representative Welch,
No.
Representative Burt,
Yes.
Representative Rhodes,
No.
Representative Green. Clerk votes no. Representative Testament,
No.
Representative Janagian,
No.
Representative Pratt,
No.
Representative Marston,
No.
Representative Harriet Gathright,
Yes.
Representative Mangiaputi,
Yes.
Representative O'Hearn,
No.
Representative Bourdonnais,
Yes.
Representative Schultz,
Yes.
Representative Newman,
Yes.
Representative Van,
Yes.
Representative Conley,
No.
Representative Bradley,
Yes.
Representative Espitia,
Yes.
Chairman Abbas.
Chair votes no.
11 nays, 9 yeas. The bill's ITL. I mean,
The motion fails.
Mr. Chairman,
Representative Pratt,
motion not to pass without amendment?
Second.
hold on, just bear with me. Just bear with me for a moment. And my understanding is if we wanted to move ought to pass, whether as originally written, my understanding is that we would still need to reconsider. We would have to reconsider the ought to pass as amended. I don't think, I'm not clear as no. Representative Pratt, you recognize to make a motion of ought to pass.
Okay, ought to pass without amendment.
Well, just ought to pass.
Okay, just ought to pass.
Has that been seconded?
I'll second.
That has been seconded by Representative Marston.
Parliamentary inquiry of the chair.
You're so recognized.
Having supported the amendment,
There is no
And
amendment before the committee.
having,
now.
forgive me, having supported a prior amendment, I believe that was 1509 that did pass the committee. Are we barred from reconsidering that? Are we barred from voting on that again, not reconsidering it, but putting that back on the bill?
Let me rephrase. You're asking if the amendment, which was 2022-1509H, can be offered again. I'm not clear that it can, but 2022-1486H can.
I believe we have a motion and a second.
Right now, listen, right now the motion was ought to pass and there's a second.
Mr. Chair,
Representative Pratt, do you wish to speak to your motion of ought to pass?
Having debated this extensively on multiple occasions, I feel this bill has a lot to offer. And at the end of each paragraph on pages 2 and 3 and 4, and it clarifies the paragraph and adds to it positive things. And then also in many places where it says may, it makes it shall. I believe all those are important additions. I think if we go back to the pure bill and vote it through, I think we'd be doing the state of New Hampshire a great service.
Representative Harry Gathright.
Thank you, Mr. Chair. If I look at this, the ought to pass, reconsideration failed, itself failed. So with the amendment, so how can you bring back an amendment when it already?
There is no amendment.
There is no amendment.
I thought,
We're not discussing it. We're discussing the bill.
It's the underlying bill.
All right.
If there was another amendment offered, but that's, I will say respectfully, Representative Harry Gathright, the amendment that you had prepared has already been ruled non-germane. So that can be taken up at any point in time on any bill.
yeah.
May I just float an idea without creating any more confusion that we already have? Thank you. Thanks to my friend from Goffstown. I had two different amendments that were suggested for this committee. One was numbered 1486 and one was 1509. To the extent that we can't reconsider 1509, someone could offer 1486.
Point of order on that. I'm sorry, but a point of order.
You're so recognized.
The clerk.
Please state your point of order.
Thank you. The clerk has alerted myself and I believe others that another amendment cannot be offered at this time. So I hope that's a correct point of order.
If you're telling me that the committee cannot consider another amendment.
I'm just the messenger, but that's what I'm told.
So then, if that's the case, then there is no amendment we can rule on. So it's just ought to pass.
Without reconsideration, that's the key point. But we've already done that, and that failed. I believe 19-1.
Representative Spetia.
Thank you, Mr. Chair. I appreciated your amendment, although I didn't support it. As the bill is stated, I thought it was much worse without the amendment. So I'll be voting no on this bill just because I think there are changes that need to be made to it, and unfortunately, once again, these changes are not there.
Thank you. And Representative Conley, in respect to your point of order, which I should have ruled on already, and I did not, which was in and of itself, it should have been a point of order. I did receive a message from the clerk that you are correct. In order to consider any other amendment, we would have to go back to the reconsideration process and do all that, which we know how that went.
A point of order, Mr. Chairman.
Please state your point of order.
I'm being told ought to pass is not a valid motion at this point. The only thing that can be done is a move to interim study or reconsider the ITL or propose a new amendment. That's what I'm being told.
Can you reference any rule or anything in any House rule or anything in the Mason's manual referencing that specific conclusion that you reached? Or any?
No, the clerk did not.
I asked Representative Burt made a point of order. I'm asking if you can reference any House rule or anything in the Mason's manual suggesting that we cannot consider a motion of ought to pass.
I'm being told that it's already failed, so it cannot be brought back up. I would like you to call the clerk to confirm that before we do this.
So that is I'm not going to rule. I'm going to rule that an ought to pass motion is proper. That's
Parliamentary inquiry.
You're not recognized for a parliamentary inquiry. The motion right before the committee is ought to pass.
Well, I'd like to speak on that.
If you were in support of the motion of ought to pass,
you're not going to let me speak?
Representative Burt, you're speaking out of order.
Well, everybody speaks on this. You don't want to go down this path. I'm telling you, you're making a fool here. So stop. Let us talk.
Representative Burt, the question is ought to pass. Would you like to speak to that motion of ought to pass?
Yes, please.
Okay, you may speak to the motion ought to pass on the underlying bill, not any amendment.
Correct. I don't want to talk about any amendments. This bill has flaws in it. And thank you, Mr. Chairman. This bill has flaws in it, and I think it's on line 25 or 26 where it should be, the law should be 630:5. It is 630:1 in here. There is other issues with this bill, and again, I come back to bottom line. They can hold these people that commit these crimes today. Let's stop this, 6 hours and 15-minute, work session. And I'm voting against this. I think a proper motion was the ITL, and I am going to hopefully see that today. And so please vote against the ought to pass motion.
Representative Newman, do you have a wish to speak to the underlying bill? The question is ought to pass.
I do want to speak about the underlying bill.
You're so recognized.
And my concern is that I am concerned trying to figure out how I'm going to vote on this bill, is I don't understand what would happen if we pass this and the motion that we passed was subsequently found to not have been in order. That's what confuses me, and I'm just going to have to wrestle with that.
I'm just going to explain that had nothing to do with the underlying bill. But anyway, well, at this point, we'll now move the question. The question is ought to pass. If you're in support of the motion of ought to pass, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
No.
Representative Rhodes.
Yes.
Representative Green. Clerk votes yes. Representative Testament.
Yes.
Representative Janagian.
Yes.
Representative Pratt.
Yes.
Representative Marston.
No.
Representative Harriet Gathright.
No.
Representative Mangiaputi.
No.
Representative O'Hearn.
No.
Representative Bourdonnais.
No.
Representative Schultz.
No.
That was a no. Representative Newman.
No.
Representative Van.
No.
Representative Conley.
Yes.
Representative Bradley.
No.
Representative Espitia.
No.
Chairman Abbas.
The chair votes yes. And Representative Marston, was you?
You voted no.
What is this?
No, I'm just, I'm allowed to ask the question. Anyway,
9 yeas, 11 nays.
I dare even wonder what happens if a motion for interim study does not pass.
Ask him if it's a good.
Representative Welch. Well, it's been finalized now. I attempted to do that. I asked the representative. Can I poll everyone's vote if you were? Representative Harriet Gathright. I'm allowed to poll the vote. It's a simple request. My understanding that it's been finalized. So yes.
Mr. Chair, point
Yes.
of information.
So Representative Welch, I'm not sure what we're polling at this point. I thought the same, Representative Welch. So at this point, there's only one motion left to make.
Mr. Chair, point of information.
I'm going to recognize someone to make a motion of interim study. That's the only available.
But
Or
does the
reconsideration.
point of information, since no other motion is on the floor, I just wanted, I got the numbers of how many people signed in for and against online.
That's we don't need that now. I think what we want to do is a tabling motion would not be a proper motion. And I would tell you this, I'm not going to support an interim study. So, but that's just me, but Representative Speed, you wish to be recognized to make an, it wouldn't matter. Then this is back. Representative Speed, did you wish to make a motion to interim study?
Yes, I do.
Is that seconded by anybody? That was seconded by Representative Harry Gathright. Representative Welch.
You can't vote till you have the audio. Okay.
It's possessed.
Okay.
Working again.
All right, mics are back. Representative Speed, did you wish to speak to your motion to interim study?
Sure. Thank you, Mr. Chair. You know, this is the idea of what happened with bail reform and where we're at. Obviously, needs a lot of studying because it just the solutions for we're just not coming up with the ones that we can all agree on. So I think we need to clearly look more into the issue and pull some actual data that's going to help inform our decisions. And hopefully we'll, make sure criminals are all not on the street, but we don't have, that we also don't have people locked away for 5 to 7 months for waiting for a hearing. So I will be voting yes to the interim study.
Representative Conley.
Yeah, we've kind of exhausted our options, save for reconsideration, which still exists. So I'll be voting against interim study with hopes of resurrecting this bill. Thank you.
Representative Burt.
Mr. Chairman, who seconded it? Oh, Welch. Okay, thank you. And so on the interim study, I will be supporting the interim study, and I hope everybody will follow so we can go home before we have to order pizza.
Any members wish to speak that haven't spoken already? Seeing none, at this time we'll now move the question. If you were in support of the motion of interim study, please say yes. If you were opposed, please say no. Clerk will now call the roll.
Vice Chairman Roy.
No.
Representative Welch.
No.
Representative Burt.
Yes.
Representative Rhodes. Representative Green. Clerk votes no. Representative Testament.
No.
Representative Janagian,
No.
Representative Pratt,
No.
Representative Marston,
No.
Representative Mangiapudi. I'm sorry. Yeah. Representative Harry Gathright.
Yes.
Okay, so that's two. Representative Mangiapudi,
Yes.
Representative O'Hearn,
No.
Representative Bourdonnais,
Yes.
Representative Schultz,
No.
Representative Newman,
No.
Representative Van,
Yes.
Representative Conley,
No.
Representative Bradley,
Yes.
Representative Espitia,
Yes.
Chairman Abbas.
The chair votes no.
7 yeas, 13 nays. Interim study passes. Fails, excuse me.
We should do a reconsideration of IPL, but I can't make that vote.
Mr. Chairman,
Mr. Chair?
is it possible that we could leave this for another time? And then go on with maybe one or two other bills where we could actually do something?
We have another bill that we can hear today.
Actually, we can hear it and deal with it.
Yes.
5 minutes.
We be in recess the committee will be in recess for till 4:30.
The other day.
Committee will now come to order. We will now reopen the executive session on Senate Bill 294. And that the this is the result. It's going to go to the House for a vote without recommendation. Representative Bourdonnais, will you complete the?
Representative Burr has already volunteered to do so.
Oh, he has.
I will,
Well,
and I'm right over here.
Sure, we'll all get a chance to read it. Will anyone wish to make a report on supporting an ought to pass? No, we'll discuss that at later. We have other business to take care of today as well. You'll prepare a report in support of ought to pass. There we have it. We now close the executive session on Senate Bill 294. Excuse me, the executive session on 294.
306.
Yeah.
And when will the blurb be required?
At this time, we'll now open the executive session on Senate Bill 306. Does anyone wish to be recognized to make a motion? Representative Bourdonnais.
Thank you, Mr. Chair. I'd like to make a motion ought to pass.
Is there a second to the motion of ought to pass? It's been seconded by Representative Welch. Representative Bourdonnais, you wish to speak to your motion of ought to pass?
Yes, Chair. I was a little hesitant on this bill because I was unsure of what crimes we were talking about updating to a penalty, to a felony. And I was shown that it is may be subject to enhanced penalties, which means that's the jurisdiction of the judge. And that makes me feel much more comfortable with possible a felony being handed out to someone with this committed this crime.
And just for clarification, I think the prosecutor has to notify the defendant that they're going to seek the enhanced penalties. That's my understanding of the procedure for that. It's purely within their discretion. Just there is a notification period, but it's not the judge per se.
But it was clear from the testimony of the family who was here that they did not feel like the person who caused the accident received a harsh enough penalty, and not enough to make them even hesitant to do texting again. So I think it's a good idea. Ought to pass.
Representative Testament?
I've had some cases, some reason to be with a friend of mine who was killed in that same area, and dealt with the same. The family dealt with the same prosecutor in the same police department, and it was only because his daughter wouldn't let go that they finally got some satisfaction. The guy got a year in jail. So I'm very sympathetic to them. But you know, it's you know, when it says May, the chances are, you know, there's a good chance in Amherst you're not going to get it.
Representative Burt.
Thank you, Mr. Chairman. I'm voting against this bill, and the reason is the state police said that there are other laws that could have been used, you know, like negligent driving and other laws. You know, I feel really sorry for the family. I do. I can't imagine. And, you know, the cost and just, you know, working through that. The 60-day plea, that guy could have got a year, and I believe with other laws that they could have filed, and they elected not to, he could have got more time. But he could have got at least a year, and he took a plea deal with the county attorney, I'm assuming, and the judge had to approve it, I'm assuming, you know, for 60 days. That's not, you know, the fault of, you know, trying to enhance penalties to felonies. You know, I've always been very careful, and I've always been very nervous about raising something, you know, from a misdemeanor A, B up to a felony. You know, I want to make sure that it's the right thing to do. Now, you know, I believe in some cases it is, but I believe, if I understood the testimony correctly, that there are laws that they could have used and they elected not to. You know, it's just rampant people distracted driving. And that's the other thing too, is I think that this should have been, you know, because I may have looked at it a little different, that if it was all distracted driving, because like I said, I've seen, you know, people reading a newspaper going through the tolls as I was coming up through, and he was passing me and the paper was in front of him, and I'm going, holy crap. You know, I mean, it's shocking to see people. You know, I have a dash cam, and some of the stuff I pick up, it's pretty remarkable that, you know, we don't have 20 crashes a day. But there are laws that would have taken this if the prosecutor wanted to go down that path. And for whatever reason, he didn't. He gave the guy 60 days. I disagree with that. He should have at least got a year. You know, so I just can't in conscience vote for this on the way it is. Thank you.
And Representative Byrd, I agree that what you're saying is correct in the sense that other charges potentially could have been brought. There's different elements to like negligent operation. So that would have to be proven. So for what this would do is really, if it's distracted driving situation. Basically, a person was using their phone while operating a motor vehicle, and then they cause a serious bodily injury, it would invoke the option of the enhanced penalty, without having to go through the difficulty of proving other offenses along with this one. So there is a difference in sometimes if you miss one element, well, not sometimes, if you miss an element on the charge, you would lose it all. You would lose the negligent operation charge. So in that case, if you're dealing with someone simply who was using an electronic device while operating a motor vehicle, you wouldn't have to prove anything other than they caused a substantial bodily injury to get the enhanced penalty. So although we agree that other things perhaps could have been done, I'll be supporting the ought to pass, but I do agree that perhaps other things could have been done, but yes.
I appreciate that to allow me to respond. You know, I agree with you, you know, but somebody reading a newspaper or a woman putting her eye makeup on, or I mean, you know, it's all distracted driving. It's all gonna, you know, could hurt one of my grandkids or hurt my wife or me, and I mean, or any of us, you know, so I understand why we need to do something here. It's just, I don't like the way this was. And I'll be honest, when the attorney spoke, you know, she really kind of turned me away from the bill. And the reason is because you know, she said at first the gentleman had no insurance. Then she says, well, he had liability insurance. and then there was a couple statements that she made and that she corrected, and I'm going, all right, well, I don't think, I don't think she's telling us mistruths, but it was just the way she spoke, turned me off on the bill. Especially the insurance part, saying he had no insurance, or the individual. I don't know if she said he or she, and that, then that he had minimum insurance. It's one or the other. So that was a red flag. But then when the officer, or the state police, he said that there are other laws that they could have used. So I'm saying, well, why are we passing something that they can do? So, that's what it is. Thank you for letting me speak again.
Representative Welch.
Yes, I'd like to take issue with my colleague up here that just got through speaking, because whether there was insurance or not, the bodily injury that he created, but whether he has insurance or not is immaterial. He caused it, and he should be punished. And I think I'm going to support this bill.
At this time, seeing no hands raised, when I move the question, if you are in support of the motion of ought to pass, please say yes. If you're opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt,
No.
Representative Rhodes,
Yes.
Representative Green. Clerk votes yes. Representative Testament,
Yes.
Representative Janagian,
Yes.
Representative Pratt,
Yes.
Representative Marston,
Yes.
Representative Harriet Gathright, Representative Mangiaputi,
Yes.
Representative O'Hearn,
No.
Representative Bourdonnais,
Yes.
Representative Schultz,
No.
Representative Newman,
Yes.
Representative Van,
Yes.
Representative Conley,
Yes.
Representative Bradley,
Yes.
Representative Espitia,
Yes.
Chairman Abbas.
Chair votes yes.
16 yeas, 4 nays, 1 not voting.
A vote of 16 yeas, 4 nays, the motion passes. Will there be a minority report?
Not for me.
Representative Bourdonnais, will you prepare the majority report? Thank you. At this time, we will now close the executive session on Senate Bill 306. There was also a work session scheduled today on which there was a work session scheduled on another bill as well. I believe it was on 292. There was no members of the there was no members of the public that were gonna speak on or offer any input on that. So I think if anything, we can go into an executive session on that. We have 2 bills left that we need to have an executive session on. I would think we can get those done today, and that would conclude all of our official business.
I'll make the motion.
At this time, we'll open the executive session on Senate Bill 292, relative to the penalty for escape.
292 is requiring notice of arrest for probation.
Oh, excuse me. Excuse me. Thank you, Representative Rose, for correcting that. That is correct. Yes.
I wish to make a motion.
Yes. 292. I do apologize for reading the incorrect title. Representative Roy, you recognize to make a motion.
Thank you. I would move interim study. Hear me out.
Second.
Representative Roy, you're so recognized.
Can I speak?
You're recognized.
Okay, thank you. Thank you, Mr. Chairman. So I held a call yesterday, a Teams meeting call with the major from the state police, the people from the parole and probation board, from the state IT that handles criminal record checks. And actually, I was able to get all those bodies to talk to each other and realize that they can do this automatically. Notification when their record is run in New Hampshire through the NICS system sends an automatic notification to whoever enters the probation or parole record into the NICS system. The problem that they were having is that they were all being entered into a central office. So one office would get deluged with notifications, and then they had to track down who that person was being supervised for parole or probation, and notification wasn't happening. So what parole or probation was trying to do is have that notification done manually. Well, after the discussion, we realized that all they have to do is each office has to enter their own probation and parole records. That way the notification comes right back to that office. So an example is John Doe gets arrested, his record is run, he's being held. At the minute that record gets run as part of the booking, an automatic notification from NICS goes to the office that supervises him for parole or probation. So the very next morning when that parole or probation officer comes into work, they're notified that their person's record has been run, and they can contact that office to find out the status of that person. So no legislation is necessary. And this is, again, at the request of parole and probation that we send this to interim study, and no law is necessary.
That's very well said, Representative Roy. Seeing no hands raised. Seeing no hands raised. Representative Marston, you recognize?
Thank you. I guess I'm just interested in asking a question of Representative Roy. In the other piece of paper that we got from Oxley, the director of the field service and so on, and the Department of Corrections, they were pushing to support this. So I'm wondering why, and reading down through some of this, I'm seeing all kinds of flags that say, yes, let's get this passed so that nobody can drop the ball.
Thank you for the question, Representative Marston. They were actually on the call with me yesterday. And after I was able to connect them with the state police and the state IT people, they realized they do not need this legislation. They are actually going to handle it themselves within the state framework that already exists. They wanted this legislation because they didn't know that they could do that. And now that they realize that that can be done, they no longer need this legislation.
I will trust your word.
And Representative Marsh, just to understand, this bill is very well intended because obviously that notice needs to be transmitted properly. However, the holding time period, I want to get into 72 hours of that time period, but that time period will not start until the notice is given. There is no solution if the notice is never given. A person's in kind of in a gray area where nowhere land, we'll call it. So this needed some work anyway, even if you were going to support passing it. So at this time, Representative Harry Cathright.
Thank you, Mr. Chair. And actually, we were waiting on data because I know that's true too. But I was just thought I remembered you guys saying that he would make sure we got data on this. But okay.
I think we on how long someone's generally held, but the 72 hours to not start until the notice is provided. What happens?
Yeah.
And I made that clear to them that proposed extension did not have a good future here. So
I'm sorry, I was out of the room. So what is it?
It's a motion for interim study.
Okay.
Representative Newman.
Thank you. I agree with everything that Representative Roy said. And additionally, just the manual process that's defined in the bill has a lot of problems.
Especially if they forget to do it. At this time, we'll now move the question. If you can support the motion of interim study, please say yes. If you're opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes,
Yes.
Representative Green, clerk votes yes. Representative Testament,
Yes.
Representative Janagian,
Yes.
Representative Pratt,
Yes.
Representative Marston,
With tongue in cheek, yes.
Representative Harriet Cathright,
Yes.
Representative Manager Pudi,
Yes.
Representative Ahern, Representative Bourdonnais,
Yes.
Representative Schultz,
Yes.
Representative Newman,
Yes.
Representative Van,
Yes.
Representative Conley,
Yes.
Representative Bradley,
Yes.
Representative Espitia. It's gone. Okay. And Chairman Abbas.
Chair votes yes.
18 yeas, 0 nays, 3 not voting.
Representative Roy, you'll prepare a majority report. Anyone want to move for consent? So moved. This time we'll now close the executive session on Senate Bill 292. At this time, we'll now open the executive session on Senate Bill 299. That is relative to the penalty for escape. Could do some reconsiderations. The numbers look very different. You want to tell your friends to come back. Does anyone wish to be recognized to make a motion? And just my understanding, this in the committee, there was a lot of confusion on what this bill would do, on how it would be applied. I was actually not present in the room. I did listen to play back some of the recording from that hearing. Just my understanding is what happened when they amended the law back in, I want to say 2015. They made a change. They added the Class A misdemeanor section. The problem is that you have a Class A section for a Class A felony, you have a Class B felony section, and a Class A misdemeanor section. But as it's written, you're either going to be in a Class A felony or a Class A misdemeanor. There's really no mechanism for it to fall into the Class B felony section. And this is designed to now allow that opportunity. I kind of looked at it as like, think of like a piece of property that's landlocked. There's no way to get to it. So this would correct that problem. Representative Roy, you wish to be recognized to make a motion?
I do. I wish to move on to pass.
Is that seconded? That has been seconded by Representative Rhodes. Representative Roy, you wish to speak to your motion?
I do. The necessity for making this bill, part of what we heard at the testimony was a problem with interstate, as one of several problems. One of them is interstate pursuit or rendition of an escaped prisoner, whereby escape would only be a misdemeanor in New Hampshire. Police are first not allowed to pursue them across state lines for a misdemeanor. Second of all, with rendition back to New Hampshire, many states will not hold or someone for rendition on a misdemeanor. So once they got across state lines, our escapees, for all intents and purposes, were in many cases scot-free. And furthermore, the seriousness of escape, and now we're not talking about just, this is from institutional, if I'm correct, is not just, it causes serious dangers for not only that inmate, other inmates, and the guards, and police at large. It creates a incredible amount of expense in trying to recover that inmate. And it creates a very dangerous situation. It shows a grave disrespect for the rule of law, for the judgment of the court, and for the institution to which they've been committed, and frankly, to their own rehabilitation. So for those reasons, I support the bill as proposed.
Representative Harry Cathright.
Thank you, Mr. Chair. I think when I made a couple notes here because we talked about the young people, the juvenile, we talked about there was no definition for the terminology escape. So, I think it needs to be defined so that we truly understand what is an escape. So if, let's say, a young person decided to leave their confinement area and let's say go to the store or something, I don't know, whatever, but with all intent to return, but it's during a time when they're not supposed to, is that considered an escape? I don't think it's defined.
First of all, I would tell you looking for the specific definition for escape that problem would exist under existing law, or whether Senate Bill 299 passes or not, it's still the specific definition you're asking about would still be a problem. My understanding is if you're in custody and you leave and no longer in the custody without authorization, that's an escape. So if you leave the facility, if you're in the medical facility, if you were to do that would be an escape. If you attempt to leave the medical facility and are unsuccessful, that's an attempt to escape. But that's, again, that definition, that's a problem under existing law as well, if that's your concern with the bill. Representative Bourdonnais.
Thank you, Mr. Chair. I appreciate the intent of the bill, but reading it, it just is not clear what it does. But I went back to the Senate bill before it was amended. That is much more clear. I don't know why the Senate, in their wisdom, decided to change the wording. But if you go back to the original Senate bill, you'll find it makes sense. This is unclear. So I will be voting against the ought to pass motion.
Representative Rhodes.
Thank you, Mr. Chairman. If I may just address the question that Representative Gathright had asked. I remember specifically when I can't remember the young lady's name was testifying, and she actually gave different examples, and she did mention specifically that, you know, in the event that a person was on like a work release program, but they were still technically in the custody, and, you know, let's say there was some kind of a traffic situation or, you know, something that was making them not be back at the time they were supposed to be, that would not be something they would consider to be an escape at all. But they do look at, you know, extenuating circumstances, if I may. So if I remember correctly, she did actually give examples of exactly what the definition of escape was. If that helped.
Representative Burt.
Thank you, Mr. Chairman. I'm going to be voting against this bill, and let me explain why. When the prison, you know, she works at the prison. I can't remember her title, but, you know, she's pretty high up. She said in the last 5 years, 30 people, in 2 this year. So last 5 years, 30 people have walked away. None were from behind the bars. One guy left a kitchen that he was working for, walks down the road, 2 hours later they find him, did no crimes. Do I approve of him walking away? No. But I also, the years I've been on this committee, I understand that a lot of these people, their education level is like a 5th grader. You know, it's not very high. So all of a sudden, you know, we're going to take this 5th grader that is a full grown person and say, okay, well, now you have a felony. You know, it's just, you know, I wish there was a mechanism where they didn't have to, you know, that it was optional, which I don't think it is. I think if you walk away, you know, you're done. She also said that home confinement is also, it's a misdemeanor right now, and it will be a felony charge if that person walks across the road off the property, you know, to see the neighbor or whatever, you know, innocently they do this. Now, there was one person, she said, from what I gather, the worst one was the person went to Virginia. They did rob a store. We need the discretion to grab those people and to punish them even more. But to walk across the road, if the person that works in that kitchen is an uneducated person, he has a 5th grade or 6th grade education, he just walks down the road, I just can't support a felony charge on those people. There's got to be another way to try to do this, and especially with such low numbers. And luckily, there was no, major crimes, done by these people. So that makes me also feel that, if this bill failed, maybe we could bring back something that would address the harsher walkaways and not the smaller ones. All right, thank you.
I just want to clarify, this is, so if it's a Class A felony if a person employs force against another person, right, or they threaten that person with a deadly weapon to effect an escape from custody. So that we're dealing with a violent situation. That's a Class A felony. That's an existing law. Now, we're talking about it's a Class B felony. This is existing law. If someone were to escape from a juvenile facility, if it's a hospital, but they're still, it's for medical treatment, but they're brought by the sheriff's department. In those scenarios, the person's now escaped from custody. All right. That is, the way the law is written today, is a Class B felony. The confusion that came up is whether that escape involved the use of force or not. So this is saying it's not, regardless if they used force, it's a Class B felony. That's someone who's in custody, who's escaping prison, that just is not exactly, it's not using a deadly weapon or using any type of force to escape. Think of it in a movie. If there's no violence involved in the escape, that would be a Class B felony. So I think if you're in custody, if you're in prison, and you try to escape, it should at the very least be a felony. I don't see any reason why you wouldn't. I understand if there is a section for a Class A misdemeanor, which would kind of opens the door for some of the items that weren't listed as a Class B felony. So if it's not listed as a Class B felony and doesn't involve force or no one got hurt, then it's a Class A misdemeanor. So, and if someone is prosecuted for that, it always could be, I'm not saying this would happen, but it could always, as part of a plea, could always be pled down to a Class A misdemeanor. That's at least an option. I'm not saying that will happen. That's a case by case basis, but I would be shocked that escaping from a prison would be anything less than a felony. That's just my take on it. So, Representative Roy.
Thank you. I just wanted to address the question regarding the home confinement and someone innocently walking across the street to talk to their neighbor. When you're on a home confinement, generally speaking, you're on an ankle bracelet, a monitor that gives you so many yards outside your home, and the parole officer shows you how far you can go. And when you leave that boundary, it vibrates, it beeps, and it sends an immediate notice to your parole officer that you've gone outside the boundary, but it still shows them where you are on a GPS. Now, if you walk back across the street after chatting with your neighbor after 15 minutes, chances are you're going to cut a call from your parole officer and say, what were you doing? He's not going to come scoop you up and try to violate you and charge you with a felony. However, if you cut that bracelet, you've now destroyed government property as well as thumbed your nose at the court and your parole officer and generally all of society. Keeping it a misdemeanor, as I said, has consequences for rendition, apprehension, and as far as I can research, I can't find any other state where escape from prison is a misdemeanor. There may be some, but I haven't been able to find it yet. So if someone's in jail on a misdemeanor now, we were going to charge them with another misdemeanor because they decided to ignore that and walk away. It doesn't make any sense. If you can't respect your opportunity to be rehabilitated, and you're on a home confinement and not behind bars, I can't see that as an excuse to let you get out of jail free card. So I will definitely be supporting this.
See no hands raised. At this time, we can now we'll now move the question. If you're in support of the motion of ought to pass, please say yay. If you're opposed, please say no. The clerk will now call the roll.
Vice Chairman Roy,
Yes.
Representative Welch,
Yes.
Representative Burt,
No.
Representative Rhodes,
Yes.
Representative Green, clerk votes yes. Representative Testament,
Yes.
Representative Janagian,
Yes.
Representative Pratt,
Yes.
Representative Marston,
Yes.
Representative Harriet Gathright,
Yes.
Representative Mangiaputi,
Yes.
Representative O'Hearn, Representative Bourdonnais,
No.
Representative Schultz,
Yes.
Representative Newman,
Yes.
Representative Van,
Yes.
Representative Conley,
Yes.
Representative Bradley,
No.
Representative Espitia, Chairman Abbas.
The chair votes yes.
15 yeas, 3 nays.
It was not final. So she can change it.
No problem. So it's 14 yeas. It's going to be 4 nays.
Motion about to pass. It's passed. Will there be a majority report? Will there be a minority report?
Correct.
At this time, we'll now close the executive session on Senate Bill 299. I believe that would conclude. I think we've now exec every bill that we have. At this time, the committee will be adjourned.
We did that earlier.
Sorry.
I thought we did. I don't know, maybe we did.
Yeah. I appreciate
My
it.
son had he's signed up for an EP class in school.
That's what we did earlier. He said we had none left. Did we do that?
Could have reconsidered bail.